It's a lying idle, my
Give the
lord.
number. Give the number.
May I be permitted? May I permit her to mention
You
item
have
number?
not filed it yet. You have not filed it as yet.
I will file and give the number.
File.
My lord, may I be
I'm
permitted?
not mentioning before filing, sir. Please
My lord,
file and come back.
May I be, actually, may I?
Mention a matter, my lord.
Yes.
That matter, it is my lord, extension of sand. My lord, during pendency of the matter, my lord, the illegally extraction is going on. To that effect, I have lodged the complaint to that. My lord, kindly take up. It's running as an item number 747 in the monthly list.
Give the number.
Actually, may I permit to mention item number 156 of my lord's list? But the urgency is that Southeastern Railway will be evicting me on 17th of May. My lord, I have served notice. My lord, I have mentioned.
Supplementary list.
My lord, supplementary. But kindly consider tomorrow, my lord. As well as I'm carrying the notice, my lord. I've annexed it to the writ petition. I'm challenging this, my lord, without any basis. They have implemented. Want to implement a scheme? The scheme does not give them power to evict me. It's only actually my 156. 156, my lord.
Item number 779.
My lord, may it appear tomorrow?
What happened?
Let me see.
The executive engineer has initiated a proceedings against me for illegal encroachment. Now, a final order has passed. Against that, I have challenged that order before the district magistrate. That is pending. In the meantime, the police and the executive engineer is coming and trying to demolish the problem.
It's in the monthly list.
Monthly list.
Give the number.
Actually, this is a contempt application.
Give the number, please.
So, Lordship, may I permit to mention one motion that urgency is that petitioner is not getting the land compensation item number 901 of monthly list and bring for operation.
Not getting compensation, you can come back after vacation, isn't it? You can wait for some little more time. Okay, wait for some more time. Let me deal with the very urgent matters now.
May I have
May I-
your lordship's
Yes.
restoration application?
Give the number, please.
May I have your lordship please for mentioning two connected matters, my lord. This matter was transferred to court number 39 for urgent hearing. On the last occasion, a prayer has been made to transfer these back to this court. Now, there's one problem, my lord. We have made an application for addition of parties, CAN 1 and CAN 6, in both of these writ petitions. Now, CAN 6 is in the file, but CAN 1 is in the file and CAN 6 remains in this court. So it's my most humble prayer that these two matters be taken up together, my lord.
Give the numbers, let me see.
Grateful, my lord.
May I be permitted?
Yes, Mr. Majumdar?
Original said mention.
Yes?
I have an original said mention.
Oh,
My lord.
is there anyone from the original?
Yes,
side?
I have issued a requisition.
My lord, may I mention?
Yes,
Item
yes.
number 480. Monthly. My lord, this matter was appearing in the daily list. It's a matter relating to my lord that it's relating to my lord employment under 2013 Act. Now, my lord, in earliest round of litigation, lordship passed a detailed order, my lord, directing them, my lord, practically, my lord, discussed everything. And in view of discussion, lordship directed to consider. In a 4-line order, my lord, they have rejected, practically without asking a reason. My lord, 3 times, my lord, adjournment was prayed for by the my lord, respondent authority for filing a report. My lord, not yet filed, my lord. Matter was in the monthly list. On my mainstream, matter was running in the list, my lord, supplementary. My lord, he's place.
Are you mentioning upon notice?
No, it is already in the monthly list. I will again note.
Give the number, let me see.
Just may I permit to mention one for non-prosecution.
Your
To be
lordship,
mentioned non-prosecution.
may I mention one matter, Your lordship? I applied for a plot of land in the new town before the HITCO. The lottery system, the lottery was conducted and I was successful. Suddenly, I was waiting for my allotment letter. They rejected my application. Now they come up with a new notification to issue a plot of land, the particular plot of land which was allotted to me, Your lordship. They have come with this new notification. They can proceed with
Give
the
the
allotment
number,
any
give the
time.
number,
Lordship.
please. Give the number.
This is in the monthly list, Your lordship.
Yes, Mr. Majumdar.
But I sent a requisition note for deputing an original side court officer in the lordship's court note to the learned register on the.
I'll inform. Yes, what is the
But-
matter?
This is with regard to those FCI matters. But there are a handful of employees left who have not been able to, who have not joined during the pendency of the writ petition. Not I filed an application without prejudice to our rights and contentions in the writ petition. We want to join. Kindly put it on Thursday's list if it's so comments. Only to that extent, nothing else.
This
the
is
repetition
very
does not-
disturbing for me also. I'm not getting.
No, I'm not
to
on
take
the.
up the matter at
We
all.
want to join, not subject to the result of the writ petition. That's all.
I think it will be proper if I send the entire matter to the bench having
It's been hard by
determination.
your lordships, kindly recollect.
I know, but
substantial-
I'm not getting time and it's really embarrassing for me. Like so many workers
Lord,
waiting.
Lordship may take your lordship's time for the purpose of only to this extent, not before the vacation, not they're really not. I'm as an advocate, I'm hard pressed. That's not I'm troubling your lordship.
No, I'll do that. I'll do that. Original site.
Only to that extent, but I shall not be disturbing your lordship. I shall restrict my submission.
File
to
an
2 minutes.
application.
Yes.
Application to hearing record. FCI matter. Thursday, application here. Should the application here.
Milord, in the similar matter, Milord, application of 116 employees are also pending. Milord. They have filed an application.
You asked, that is addition of party.
And probably they will be paying for the similar relief
We have served.
to join without prejudice.
Due to application here.
My lord, may I permit you to mention, my lord, 3 matters, my lord. Matter relates to the short-term analytics. My lord, urgency is the Chondichoran is for my other side, my lord. My lord, only consideration order, my lord, but the
Give
urgency.
the number, let me see if I can take up. Give the number.
My lord, only urgency is, my lord, the department is going to auction, my lord. That's why, my lord, only consideration. order.
Numbers, please. Give the
Lordship,
numbers.
lordship, grateful.
Yes, call the list, please. Jalpaiguri circuit.
Circuit Court of Jalpaiguri, item 1.
My lord, this is appearing at my instance, my lord, for extension of interim order. My lord, pursuant to, we have served notice on
This is
the
a contempt matter.
item.
Jalpaiguri, Jalpaiguri. 10 of 2023. Yes.
My lord, today, my lord, I missed. I do not.
For this matter, yes, you are appearing. Mr. Dey, you submitted that the order has been complied with, but you should come back with an affidavit of compliance.
Yes, my lord, affidavit is complete.
Thursday or after?
No, my lord, tomorrow.
Very well, not today,
Not to.
not today.
Regular bench matter, item 1.
Who is appearing for the respondents? Mr.
I am
Mark?
appearing for the respondents, my lord. I have submitted the report in the form of affidavit. And my lord, this is relating to the determination of the lease. Lease has already been determined.
My lord, this is appearing for the extent of the extension of interim order, my lord.
My lord, as the matter is ready, my lord,
My lord will kindly grant a small
Let
extension.
it be urgent till the urgent, extended till the urgent date.
my lord, already, my lord, the lease has been determined. It is, my lord, the kindly, if your lordship kindly go through my
The next date.
My lord, we are
They
agreeable.
grant an extension till the next date.
next date. Yes.
We are also interested in getting the matter, my lord.
It's at the motion stage.
My affidavits are complete, my lord.
Is it?
Report has been given. Report
It's
has
a report, so it's at the motion stage.
report, yes.
A report in the form of affidavit and exception to the report have been exchanged. Paragraph, let the matter appear under the heading motion on 22nd June.
My lord.
Paragraph, the interim order granted earlier is extended till the adjourned date.
My lord, I am humbly requesting, can it be extended for 5
No,
days?
no,
more, my
no,
lord,
no,
so
no,
that,
no.
because in
We
case it
are
reaches the list.
opposing.
My
I am strongly opposing.
Item 2.
I'm appearing for the petition. The restoration application.
Have you served?
The facts of the case is very. I have not. 81 lordship. It is alleged that the respondent authority has set up pipeline and boundary wall over the land of the petitioners. So if a lordship directs the petitioner, opposite party respondents, conduct a inquiry, and after giving an opportunity to the petitioners, they have, if they found that it is illegally submitted on the land of the petitioner, they have removed the same. Already the writ petition is filed. Direction was that to file the report by the respondent authority. Till that the report was filed. The matter better be they considered themselves. First recent order, and if it found it is laid down in the land of the petitioners, they remove it.
There was an order on 4th December 2020.
Further, there was an order for the last chance. Still, it is a departmental governmental issue, but let them decide on about giving an opportunity to the petitioners and hearing.
An order was passed on 4th December 2020 for visiting the local, preparing a site plan, demarcating the land of the petitioner, showing the course of water pipeline. Has this been complied with? This has not been complied with. So let this be complied with. There is already an order, Mr. Dev. Is there a representation pending?
Earlier, there was a representation. As the authority did not do anything, that's why the petitioner come before the petitioner is a senior citizen. She wants only to get rid of the problem efficaciously. And
Because an order has already been passed. After that, there is a, yes. Do you agree to this, the proposal?
Lordship, if the relief be solved in the
Where is your representation?
30,
Page?
page 29. Lordship. The authority decide in 2 or 3 weeks or within a month.
Within a month?
Lordship. Project
Can 1 of 2023. Restoration. Eloquent.
Kagdi.
Order passed on 24th March 2023. Restored. WP the order. Third learned counsels for the parties. It is paragraph. It is contended on behalf of the writ petitioner that the state respondents have encroached upon the western side of his land by installing pipeline and they have raised a boundary wall also and raising a boundary wall. The petitioner submitted a representation in this regard before the concerned authority, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the respondents that the fourth respondent, executive engineer, the fourth respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the representation is the writ petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated 10th September 2020 within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. Both disposed.
Item 3.
My lord, I beg to appear for the, my lord, this is that matter where Mr. Shengupta is appearing, they filed a. My lord, I have already served notice upon them as per my lord's order dated 8th of this month, my lord.
Yes, anyone appearing in the review application? Anyone appearing in the review application? RVW 41 of 2022. None appears for the applicants.
My lord, it will be 30, my lord. The new review application is 30 of 2023.
Is it appearing in the list?
Yes, ma'am.
of 2023. None appears for the applicants. Stop. No accommodation is sought. It appears that the applicants are no longer interested in proceeding with the review application. Paragraph. In view of the same, the review application being such and such is dismissed for default. There shall, however, be no order as to costs as in certified website copy. CPN 368 of 2022. None appears for the alleged contemner. Stop. No accommodation is sought. Paragraph, the alleged contemner is directed to show cause as to why a rule of contempt shall not be issued against him for non-compliance of the order under contempt and non-appearance before the court, despite service of notice. Paragraph, the department is directed to serve notice upon the alleged contemner and submit a report to that effect on the adjourned date. Paragraph, let the matter appear under the same heading on 13 June.
Grateful.
Item 5.
Sir, I am for the petition, my lord.
For the respondent number 1.
Your Lordship, I am for the
Union of
respondent IOCL.
Yes.
Respondent.
My lord, dispute about the non-payment of proper compensation of the using of bus tool and my lord. Kindly consider my lord representation page 18.
Page 18.
18, 18, my lord.
Your land has been acquired.
Using the pipeline division, my lord,
Yes.
but no proper compensation, my lord.
Using the,
Pipeline division, IOC, Indian Oil Corporation, my lord.
has your land been acquired or it is the user?
Not acquired, my lord.
So this court doesn't have determination.
Yes, Your Lordship. It has not been acquired. It is being used, but it should be dealt with the petroleum and minerals pipelines acquisition of rights of users inland act. Your
If
Lordship.
it is acquisition of right of user, this court has no determination. I have to release it.
Section 10. Your lordship, this is my humble submission. This matter actually should be filed before the competent authority under where under section
I
10.
cannot deal with that. I'm sorry, this court, I have to release the matter, that's all. Affidavit of service. Can you tell me the act, the
Hello,
name,
yes.
the complete?
The petroleum and minerals pipelines.
The matter pertains to the act taken. Paragraph, the matter is released due to lack of determination.
Item 6.
I am for the petition amendment.
Yes.
Affidavit of service.
Respondents,
Served, my lord.
you're
There
a,
are private. I am for the statement.
This is
what about the private respondents?
served, my lord.
Yes.
This is the third round of litigation, my lord. First, my lord, your lordship directed the assistant engineer to consider my representation. They did not. Contempt was filed. In contempt proceeding, they told that, my lord, the TN1 notice was issued. Subsequently, contempt proceeding was drawn up, and in September 2022, 10-2 proceeding was lodged before the 10-3 proceeding was lodged before the SDO. But that proceeding is still pending, my lord.
Mr. Ganguly.
But your lordship kindly direct the 10th precedence, if it is not yet completed, it has to be completed, if it is leave it afloat. I do not have any objection to that. It has to be completed. But I heard from the local OC, there are furor over the place because of the Durga Mandap, not the Durga Mandap is there, the local villagers are going and worshipping there. Though yesterday night I talked to the OC concerned, he said that they have gone 3 to 4 times. However, they are also consoled them. They have said the local villagers has already assured them that that will be broken down. Yesterday night I have talked to the
Within 1 month.
within one. Yesterday night I have talked to the concerned OC, that is the Sobong PS. And 10-3 proceeding, if not drawn, it has to be
No, it
completed.
is pending. That is what.
Pending. Then it has to
Pending,
be
my lord.
Affidavit of service. None appears for the private respondents despite service. Paragraph. Third, learned counsels for the parties. Paragraph pursuant to an earlier order of this court, comma, a court alleging encroachment of PWD road by the private respondents, comma, proceeding under section 10 of the West Bengal Highways Act 1964 was drawn up. Stop. Paragraph, it is submitted on behalf of the petitioner that though proceeding under section 10(3) of the Act of 1964 is pending, comma, it has not been disposed of as yet. The petitioner prays for a direction upon the concerned authority to consider and dispose of the proceedings within a stipulated time frame. Paragraph, it is submitted on behalf of the state respondents that the
Respondent number 4, my lord.
that the fourth respondent be directed to
4 and 5, my lord.
Local sentiment is
not
playing
five.
over there.
It is only SDO.
Yes,
10(3).
local sentiment is playing over.
Directed to conclude the proceedings in accordance with law. Paragraph, local sentiments cannot
My lord, I have
Proceed.
just said the night.
the law, isn't it? They have to take necessary steps.
It will be done.
In view of the above, the writ petition is disposed of, directing the fourth respondent to take the proceeding under section 10(3) of the Act of 1964 pending before him to its logical conclusion within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of, chapter.
হলো, তোমারটা হলো তো?
Item 11.
For the petitioner, my lord. It is matter relates to my lord, forged stamp paper, my lord, covered by my lordship judgment, my lord.
Yes, Mr. There is a bit. The petitioner's father purchased the land.
Yes, my.
Affidavit of service. It is contended on behalf of the petitioners that their father purchased the plot in question by virtue of a registered deed of conveyance on 19th March 1991 in the names of the petitioners jointly, but the concerned authority refused to hand over the registered deed to the petitioners on the ground that the stamp papers used in the said deed were forged. Stop. The petitioners pray for a direction upon the
Respondent number 2, my.
second respondent to deliver the registered deed of sale in their favor upon the petitioners replacing the genuine stamp paper of the same value in place and stead of the forged stamp paper. The petitioners seek to deposit the sum equivalent to the allegedly forged stamp paper used in the deed before the second respondent Within a month?
Yes, ma'am.
Within, no, he'll deposit the amount within a month.
I am not on that. There was, my lord, on that.
Father has executed in the name of the petitioner, the deeds.
The name of
No,
The
petition-
deeds are in the, deed is in the name of the petitioners.
Yes, ma'am.
Within 1 month from date. Where is the deed
My lord, in the office, ma'am. On some,
of the second respondent?
yes, ma'am.
The petitioners submit that the deed in question is lying in the office of the second respondent. Paragraph, it is submitted on behalf of the respondents that upon the petitioners submitted on behalf of the respondents that upon the petitioners depositing the sum equivalent to the allegedly forged stamp paper in the deed, the second respondent be directed to hand over the original deed to the petitioners if the said deed is traceable in the office of the authority. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to hand over the original deed to the petitioners within 2 months.
Yes, ma'am.
Within 2 months
Yes.
from the date when the petitioner deposits the amount equivalent to the allegedly forged stamp paper used in the deed. Stop, upon receipt of such amount, comma, the second respondent shall deposit the said amount in an auto-renewing interest-bearing fixed deposit account in any nationalized bank. Stop. In the event the original deed is not, let that be there,
Yes, ma'am.
not traceable, the second respondent shall hand over certified copy of the deed in favor of the petitioners within the said period. Paragraph, with the above directions, WPS such as disposed of. Chapter 10.
Item 12.
Well, madam, in this matter, I am appearing on this. This is my affidavit of service. That is the construction of a PWD land. In
Who
front
is
of,
appearing for the respondent?
I have served notice.
Give me a minute.
Where? I was appearing. I was reading the bit. Oh, 9.
Item number
16.5.
Oh, 16 তারিখে থাকবে।
This is 12.
12 16 তারিখে থাকবে।
Private respondents.
না 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 আমি নেই। My lord, my representation, that is page 70.
Please give me a minute.
Yes, yes. I have served all, only one person, that is the respondent number 13, refused. Marked refused. It is a good service. I have annexed this envelope.
Yes.
My representation, that is page 70. 17,
1964 Act.
1964. That is the 10 one.
Who is appearing for the state?
I have served notice.
Mr. Ganguly is not appearing in this matter.
No, no, no.
Mr. De, may I request unauthorized construction?
Unauthorized construction. That is representation should be considered under section 10.
So let this be disposed of.
Disposed of. By directing the respondent number, that is 5.
Yes. Affidavit of service. None appears for the respondents despite service. Paragraph, Mr. De, who is present in court, regularize quorum, copy service. Please serve a copy to Mr. De.
Yes, yes. I will give a copy.
Paragraph,
Acho. 12 pe acho.
the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have encroached upon a portion of the PWD road adjoining his plot by raising unauthorized construction therein. Stop. The petitioner submitted a representation in this regard before the concerned authority on 17th March 2023 and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the fifth respondent be directed to consider the representation in accordance with law. You filed it in March and you are before the court in May.
My lord, already 1 month lapse, 1 month before lapse. My lord already received it.
In view of the above, the writ petition is disposed of, directing the fifth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents in accordance, in accordance with law. Disposed of.
That is 13 also the same. I have served notice.
State is not appearing in 13. You are in 13.
Affidavit of service kept in the record.
Private respondents are served.
Served, 2 refused. I have also. That is 11 and 12 refused. Respondent number. That is the same respondent number.
They appear. Court appear. No, regular. No,
Only date of
for
representation.
the private respondents despite service. Fifth respondent. Same. Date of representation is
Said 28 March 2023.
28. This is 24th.
Or 24th
call it-
March,
they call it-
24th March, 24th. Sorry,
24th March 2023. Representation. Same one. Fifth respondent.
fifth respondent. Deeply obliged. Affidavit of service kept in.
14,
Yes, 14. You are appearing for the petitioner.
Opposite part.
14.
14. Who is appearing for the petitioner?
My lord, I am appearing for the petitioner.
Yes.
It is an writ petition, my lord, for removal of encroachment on my line. Before my line, what's happened, my lord? Respondent number 9 to 16. They are obstructing my ingress and egress before my entrance of the gate. And in the internals of PWD, my lord. We have informed the PWD in February 2023. Your lordship finds at page 15 and page 18. 18, we have made a complaint with PWD to do the obstruction made by the private respondents, but nothing has done. I am before your lordship. For asking the PWD remove the obstruction, because my right to property has been withheld, my lord. Right to property under section under Article 300A article has been infringed, my lord. Constitutional right, my lord. The PWD did nothing, my lord. I am before your lordship for removal of the encroachment under West Bengal Highway Act 1964 rule section.
Yes, let us hear the state.
Yes, my lord.
Mr. Kuchai.
My lord, let the representation be considered by the concerned authority in accordance.
Has proceeding been started? No.
No proceeding.
Yes.
Lord, so far as submissible unless referring is concerned, my lord, there is no encroachment as such. If the opinion is will be
That's
will be
right.
considered, it will be considered, but I'm.
Let it be considered. You will be given an opportunity of hearing.
Let me be given a right to.
Yes.
Fine.
Representation কোথায়? Representation
15 and 16.
Heard learned counsels for the parties. The petitioners claim to be the recorded owners of the plot in question and submit that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining their property, thereby obstructing their egress and ingress and causing hindrance in enjoyment of their property. The petitioners submitted a representation before the concerned authority
At page
in this
15, my
regard.
lord. 15 and 18.
on 8 February 2023, which is yet to be considered. Stop, the petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondents that no encroachment has been made on any portion of the PWD road. Stop. However, the private respondents have no objection if the representation of the petitioners is considered by the concerned authority upon affording them an opportunity of hearing. Paragraph, it is submitted on behalf of the state respondents that the assistant engineer, third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law.
May I, one indulgence, my lord. The private respondents have made unauthorized construction on my, before my line.
I have recorded that.
Lord,
Yes.
that my lord has not gone into the main subject.
my lord, hard everything.
Not necessary.
It
I
is
would
all
have recorded
contained
your
in my petition, my
submissions.
lord.
Disposed of.
I'm getting.
A proceeding has to be drawn up.
Punuru is also my lord, same matters. 15 also, my lord, same orders.
You are appearing?
Private respondents.
Representation. Who is appearing for the private respondents in 15? Where is your affidavit of service?
Affidavit of service.
Petitioner. Actor.
আগেরটাও 14 হ্যাঁ নামটা লিখে দিচ্ছি।
ওটা এফিডেভিট দিয়েছে 858
লিখে দিয়েছি আপনার নাম কি?
None appears for the private respondents despite service. Where is your representation?
Page 22, my lord. Page 22.
Dated 30th December 2022. 30th December 2022. Within 3 months upon giving opportunity.
Get
Private respondent submission বাদ যাবে। Submission টা বাদ যাবে সেটাই বলছি।
This has been posted on, my lord, 27th of January 2023. my lord. Representation is posted, my lord. Can you see on the bottom of the my representation, my lord? Dated 30th December. About 1 month. Poster receipt.
27 January doesn't matter.
Yes, my 27th, they are posted.
30th December. That doesn't really make a difference.
16.
By 16, before my learned senior friend starts, I take a preliminary point that the necessary party has not been impleted. Why I'm telling my learned friend initially filed a writ application for removal of the unauthorized encroacher. Your Lordship the earlier been directed, the SDO will text him in accordance with law. Thereafter, my lord, those encroacher who has been order of eviction was passed.
For whom he is appearing? I could not understand.
My lord, what happened, my lord, thereafter that those encroachers, my lord, move before your lordship's court and obtain an order of injunction.
You are appearing for those encroachers?
States. Why I'm telling?
State. You are appearing for the state?
Yes.
Yes.
Why I'm telling, my lord, because in the writ petition, statement has been made that your lordship pass interim order, stay of the eviction order. Now, my lord, in this writ petition, he wants implementation of that eviction order. Now, my lord, without those being made party or my lord, this is my submission, my lord, whether this writ petition your lordship can take up.
Let me make my submission. Now, in terms of the
court's order, the SG passed an order under the Unauthorized Occupancy Act 1962. But this order at page 68. Now of the total 48 unauthorized enclosures. 41 came before the Lordship. I have annexed this order. Your Lordship stay this order up to 30th May. Now, my lord, so far the private response is concerned, he appeared before this collector, he was heard. But so far the other inquiries are concerned, they were not heard, that's why they moved this application before Lordship. Now, my lord, he did not move any application before this honorable court. So far the private response is concerned, his encroachment has to be removed because the SDO order was clear to that extent that if you do not evict this, evict from this suit land within 15 days, appropriate action will be taken. You lost it from the section 5 of the Act, how the poison will be delivered. This is the section 5 of the Act, kindly see. So I am, my lord, came up before Lordship and came up.
This order has been stayed by a
So far the
coordinator.
other petitioners concerned, I have annexed this order. Kindly see.
Where is the stay order?
Yes, yes, kindly see. Page 75. No coercive action will be taken against the petitioners. Page 75.
Page 75 is the order of the subdivisional officer.
74.
First 74, then page 74. Since no coercive action will be taken up against the petitioners, but the private response is concerned, he did not move this application. This order has to be implemented against him.
Yes, yes.
Paragraph 8, I have said so. This order is so far restricted, so far the petitioner is concerned. And since he did not move this application, this order has to be acted upon as per section 5.
Page 74 is extension of the interim order. Where is the interim order?
The interim order till 30th May.
Interim order.
That order, I know that the order till 30th May.
No, my lord, in my brief, that is at page 75.
There are 2 pages marked as page 75.
Order dated 14th March
14th March
2023.
2023, yes. Now, who
That's
are the
what-
petitioners in this matter?
My
Who
lord,
are the petitioners in this?
I don't know, my lord.
the
because-
petitioners going to give, so but this matter that concerned 41, the petitioners. I have stated in paragraph 7.
Do you have a copy of the writ petition?
Yes, I have the copy of the petition.
5448.
I have the copy of the petition. I'm giving.
Who is appearing for the private respondent in this matter?
Well, kindly see the copy of the petition. The private respondent is not named in the petition. Paragraph 8, I have stated so. Let him show.
This is 4679.
Yes.
The writ petition is 5448.
5448 is concerned, there is no, I have not purchased that petitions because I have stated in paragraph 8.
Interim order was passed in 5448.
Yes, I know that.
So where is that writ petition?
But there are 21 writ petitioners, total 41.
Please give me a copy of the writ petition in
But that copy of the
5448.
petition have not been served because I was not made a party there. And then that's why I have stated in the paragraph 8.
Mr. Kuji, do you have a
Achha.
copy of the writ
No,
petition?
my lord, I was not in that matter, my lord. Other state advocate appeared.
Because my lord,
5448. Oh, this is, let it be not today. 5448 is fixed tomorrow. Mr. 5448.
the copy of the then the copy of the petition is with the records, my lord. You know, sir,
Yes,
that's-
5448 is appearing tomorrow.
Yes,
So let it is
Then,
not.
my lord,
yes,
let the order be passed. Let this matter appear along with my lord 5448.
Tomorrow 5448 is appearing. Third learned counsels for the parties. Let the matter appear under the same heading on calculated. Ah. 16th. Along with.
Okay.
Along with WPA 5448 of 2023. Please take back your book.
Item 17.
No, my lord, this is the case. The third time, I am actually knocking the door of the Temple of Justice for obvious reasons. Both the order was passed by your lordships. I'll come to that, my lord. Let me just explain in short what is actually my case.
Who is appearing for the respondents?
Development and I have just service. The my lord, the lease deed that was executed in my favor. If your lordships can take trouble to come at page 38.
Yes, the deed.
Have you also got it, my lord?
Yes, yes.
Then kindly come to the, when it was done, 24 November 2017 at the top. Then my lord, kindly take trouble to come at page.
No.
ওই পেজটা কোথায় টার্মসটা 68 just next 68
Yes.
clause 5. Have you also got it, my lord, at bottom?
The force majeure clause.
I'm grateful to you, like failure on the part of the lessees to fulfill any of the terms and conditions of this lease shall not give the state government any claim against the lessee or be deemed a breach of the lease. Kindly mark it, or deemed to a breach of the lease. In so far as such failure is considered by the state government to arise from the said force majeure, and if through force majeure the fulfillment by the lessee of any terms and conditions of this lease be delayed, the period of such delay shall be added, kindly marked in my love, shall be added to the period fixed by this lease in this clause. The expression force majeure measures God, war, missions, I have civil, psychic, quick, tidy, storm, sunlight, flood, explosion, fire.
Lord, order input as page 108.
আর ভাই দাঁড়াও না, আমি তাহলে আরম্ভ করেছি অর্ডার ইনপুট তো আমি যাবো another happening and which the lessees could not reasonably prevent or control. So that is very relevant. Now what is actually happened? I started the excavation, no problem. What is happened? The road through which the trucks are coming and going, they're totally gone. So a circular is issued with the DM. Page 87. If you lost it, kindly take up to come page 87.
Yes.
80 has you got in my lord?
Yes.
Appraisal or type of পড় ভালো করে দেখতে পাচ্ছি না পড় জোরে পড় এই ভালো করে টাইপ করিস না
Eligible copy, my lord. There is chance of every apprehension of emergent situation due to deplorable load condition on the Gohogram Road via Adradhai, Paharj to Silia Road and Paras to Sotepur via Lower Pur. Therefore, the third paragraph, the Mohammed Inau Rahman, WPC District Magistrate and Collector, Purba Bardhaman, do hereby under section 115, 117, 126, 128 of the Motor Vehicles Act, reduce subsection so and so, imposing restriction on movements of all kinds of heavy loaded goods vehicle at the following road.
So that is that was closed. It is beyond my control. I never expected. So even if I extract the sand, I cannot keep huge number of tanks. It's all not possible. Everyone has his own area. So I'll have to carry that. I'll take it out. And that is the only road through which it will be done. Kindly marked very relevant. That is the only road. That is closed. So naturally my business is stopped. Kindly take trouble to come to next page. It's a completely better.
Whereas the notification of restriction on movement of all kinds of heavy loaded goods vehicles was imposed period so and so dated 25 March 2021. Whereas a proposal has been received from the Superintendent of Police Purba Bardhaman for the relaxation of vehicular restriction on the Golsi Grogram Road via Aryadahi with a memo number so and so. Therefore, it is hereby ordered that by notification of restriction over the policy to Gogram Road by Ariadati hereby is withdrawn, expecting as.
Anyway, that's, now my lord, kindly see the first 89, 87. What is the date of the order? 25th March 2021 at bottom. And what is the withdrawal? 22nd February 2022. Near about 1 year. My entire business was stopped. As per force majeure clause, I'm entitled. So I made a representation. Nothing was done. Kindly come to come, my lord. My lord, order 92. 92.
Yes,
It is my lord, order, my lord. Hard Lord, I will also got it, my lord.
yes,
Hard Lordnet Council being the highest bidder in the e-auction floated by the state government.
this is an order for consideration of the representation.
And kindly see, my lord, in view of the second page, third paragraph, it starts with in view of the above.
Yes,
The read petition is disposed of directing the second respondent to consider that dispose of the representation submitted by the petitioner within 6 weeks from the date of communication of this order in terms of clause, kindly marked it, my lord. Let my lord pass that order in terms of clause 5, part 9 of the deed of lease, as well as the notification such and such and such. So it was the direction by lordships after considering the entire aspect, what is to be done, representations. Then my lord, page 100, kindly come to page 100. Have you also got it, my lord? Page 100.
yes,
After scrutinizing all the relevant documents, it is found that the long-term binding lease, the petitioner was registered date, such and such date, constancy. Hence, the said lease of the petitioner is valid till 20th November 2022. It may be presumed that in view of the notification dated 25th March 2021, issued by the district magistrate Purva Bardhaman regarding restriction of vehicle movement, sand mining activity of the petitioner was duly affected till such and such. It is a view of the, my lord, DM himself. Now, at one thing is very clear, my lord. One reference has been taken. I'll come to that, page 101 at bottom. Page 101 at bottom, my lord.
yes, yes,
By requesting to consider the matter sympathetically, is as inability to carry out the mining operation is beyond the control of the lessee. Very clear, everything is done. Then, kindly come to 105. The last order by your lordship. Have you got it, my lord?
yes,
Hard the order passed by the court and such, the representation submitted by the petitioner was taken up for consideration by the district magistrate Bankura, forwarded the same to the assistant secretary to the government of West Bengal, Department of Industry, Commerce and such, for sympathetic consideration of the representation since, according to the district magistrate, he was not in a position to extend the lease period in view of the new sand mining policy 2021. So, my lord, prior to that, 2017, that was executed. So, naturally, my lord, no evidence has been given. They cannot use in my case. That is why DM says no, it should be considered sympathetically, and he is not at fault. My lord, at the time, passed the first order. My lord referred that clause of force majeure. There's no doubt. Then, my lord, I'll come to 120, 120. This is 120. This is the representation by the petitioner along with others.
Transport Department is 187.
Reopen Golsi, Goagam Road. I made a report. Can you see the date? 7 December 2021. Why I am referring? Because the authority at the time of passing of the order did not take cognizance of this aspect. I made a representation. I said, no, you don't represent. How is it? There we requested. Last paragraph, sir. We request you to reopen the road for heavy vehicles so that we can start operating the sand mining and such. No allegation against me. They cannot blame anything. Everything is all right. The problem which was created, that was created due to their action. I am not at fault. So I wanted to have clause 5. Now kindly see the order. Page 108. 108. Kindly come to 108.
yes,
This is the order. hearing complaints answered. During the course of hearing, this hearing, second paragraph, petitioner mentioned that the long-term mining lease deed such and such 5 years, registered such and by and petitioner. The petitioner further mentioned that there is one route for communication to the leased area, namely such and such. Paragraph 4. Actually, the petitioner further mentions that the TM collector notification immediately thereafter will be started mining activities. For a period of 10 months, 29 days. That means for 11 months, it was stopped, which is beyond my control for invoking the said clause 5. The petitioner accordingly finds it getting no response to answer. These are all the history, my lord. His ordering portion, very short, very peculiar order. Page 110.
Yes.
Clause 10. Kindly see what type of order is. I am really surprised. I have got it, my lord. Now, after careful consideration of the representation 18 hours of the petitioner in the written arguments stated about the report available in the department, it is found there was no restriction or excavation of the sand from the sand, but a very peculiar sand. Who have I ever said? Even if I excavate, there is some limitation. I cannot excavate entire quantity. What's what I keep it? I cannot stack entire goods over there. Unless it should be carried out. Then it is found that there is a restriction on excavation from the sand mines stated above for the period of 2022, and also the petitioner has got almost 9 months even after withdrawal of the 580 order. I am concerned about my 11 months. That should be added. Totally misconceived, my lord. What is the force majeure? Period which beyond my control. That should be added in the list. He is calculating it different to me. Now he got the 9 months. Doesn't matter. Even if I get 1 year, the period which I have lost, that should be added. That means another 11 months should be added in my list. 9 months, even after withdrawal of the 550 order or movement of heavy units of vehicle issued by DM and collector to the book. Neither did he make any pay to DM or not allowed him. Again, mistake. That's why I do the logic attention. In writing, we pointed out, kindly do it. It's a total non-application of mind. His attitude not to give anything. And that's why minor specifically in your lordship's order mentioned, keeping in mind the clause 5. So how he can pass such a report? It's totally illegal. He cannot deprive me from having this particular. And when his own officer, TM, he recommended, yes, he's not at fault. I made a representation to reopen. It was not done. Now he's blaming me. Why did you not excavate the sand? How will you excavate? Some space must be there to keep. And if the movement is stopped, where I'll keep it? So all irregular. And last thing, no representation is made. It's a total non-application of mind. Now, my lord, this is the third time. I praise people also the earlier occasion. Still, I am tempted to cite again this judgment. Because as you know, my lord, power of your lordship mean High Court as a whole under 226 is much more wider than the power to some extent the Supreme Court Super Article 226 is concerned. 226, even a foreigner can move with application. Article 32 cannot. Because Article 32 only a citizens that is having the fundamental right. Foreigner do not have any fundamental right. So it's a very wide power. And the 3 judges of the Supreme Court, and eventually before these 3 judges had a privilege to appear in some cases, my lord. Justice R.S. Patel, A.P. Sen, and D.B. Madan. Very first day we took oath, sitting with senior Chief Justice Father, Chandrachud, senior. I moved this. Kindly come to paragraph 19. I'll just hand over the book. 1996, 2 Supreme Court cases, 679. Peculiar. How can I do that? 679. Yes, I've got it, my lord.
Paragraph 90.
No.
Paragraph 90.
86 3. 86 2 86 3.
Paragraph 90.
I'm reading then. My very efficient clerk, not 2003, is that 2002, 19. I'll read for, kindly allow me to read, my lord, because I really like this judgment. It's so white power. Even though I was not even aware. May I place it, my lord? In Holmesbury's Laws of England, 4th edition, volume 1, para 89, it is stated that the purpose of an order of mandamus is to remedy defect of justice, and accordingly it will issue to the end that justice may be done. In all cases where there is a specific legal right and no specific legal remedy for enforcing the right, and it may issue in cases where although there is not a legal remedy, yet that mode of redress is less convenient, beneficial, and effectual. There is thus no doubt that the High Court in India, exercising their jurisdiction under Article 226, has the power to issue a writ of mandamus or a writ in the nature of mandamus, or to pass orders and give necessary directions where the government or a public authority has failed to exercise or has wrongly exercised the discretions conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion malified or an irrelevant of the applications with a lots of experience from both sides as the judicial part, my lord. No, I just directing the constitutional case. I was a little upset. There's a hide and seek. The court could have passed this order. Anyway, what can be done? This is the third time. For obvious reasons, my lord gave them an opportunity. My lord didn't use up the power of all those authorities. But this is the high time, not the time has come. In spite of your lord's specific directions, in spite of the observation of their own officer, that force must will apply, in spite of the fact, whatever policies that are subsequently implemented without any retroactive effect, how they can deprive me all irrelevant consideration and without considering the relevant aspect. So that's why I most humbly beg, my lord, here is a case. The time has come to direct the authority. No, I am here to do the justice. And law doesn't mean to be a mere theoretical abstraction. It is an instrument to do the justice and justice for all. These persons has come before me for third time. Repeatedly, I gave you opportunity. You have totally misused that. Your discussions has not been properly exercised wrongly, and irrelevant consideration, relevant consideration has been overlooked. So kindly pass this order, my lord.
Yes.
Schedule of the Milord lease deed, Milord, schedule.
Schedule of the
Page 41, schedule of the lease
Deed.
deed. Lordship,
page 41.
41.
Yes.
Has your lordship got it, Milord?
Yes.
And your lordship kindly takes, Milord, all that tract of land situated at Mousa such and such, bearing plot number such and such under PS, Patroshayur, district Bakura. So, Milord, lease deed, Milord, in respect of district Bakura under police station Patroshayur. And he is referring, my lord, learned senior friend is referring a notification of transport department that relates to Milord Bardhaman. Purbo Bardhaman, page 87.
That is the route.
Page 87, Milord. And Milord, there is a Milord stipulation in the acts and rules relevant. Milord, he could have asked for Milord stack permit. Milord, he didn't ask for it. Milord, other transportation stack permit, he didn't ask for it, Milord. And page 110, Milord, absolutely reasoned order. Reason has been mentioned, Milord, during that period of time, Milord. Period has been mentioned, Milord. If you,
Do you have a more legible copy of this notification? Because it cannot be read. It's-
Well, I'll give that. I'll give
Milord,
that.
what you, Milord,
I'll give that, my
there
lord.
is no scope of any granting any interim order, Milord.
What interim
Your
order?
lordship, Milord, kindly directs us to file affidavit in opposition.
For 10
Milord,
years.
that's fine.
Necessary, not necessary. Give me, please give me a legible copy.
Yes, yes, I'll give it. But one thing is very clear. He is now saying it is at Bankura. But road is there.
He
He
could have
blamed it so. Why?
You can at best come back with a report in the form of.
Lordship,
affidavit
Milord,
if you want to,
lordship.
Because he's
Yes.
representing the authority.
Yes,
So let him come back with a report.
lordship.
In the meantime, please give me a legible copy of this
Yes, yes.
notification,
Of course,
because it cannot be read at all.
I'm begging unconditional apology, my lord. I'm begging unconditional apology, my lord.
The route,
I couldn't read, my lord. Saying.
the route needs to be seen because
Lordship.
learned.
Yes, yes. My lord, kindly see the interesting. I could have understood. At that time, my lord twice get an opportunity. Consider. They got enough opportunity. They say, how is Mr. Manager, your client? Operation is Bankura. It is the Bordhuan. And the route is there. The route has been blocked.
Could ask for stack permit, Milord.
What check permit?
That
The
provision
road
is
is
there, Milord.
road is broken.
Please show me the necessary provisions.
Well, Milord, I will file my, Milord, report.
Let him come back with a
Yes.
report.
As you lost it, but vacation interval it will take not much time.
Immediately
up-
after vacation.
Yes, Milord.
My lord,
Come back immediately after vacation.
as you lost his my lord.
The mineral development doesn't have to say.
Notification of the particular road that is, if I am not wrong, it's around 60 kilometers away from the mining lease. Lordship, there is no restriction because of non-plying of vehicle. It cannot prevent the petitioner to extract sand. He could have asked for permit of stock, that because of the reason I could not transport the sand. So kindly issue, there is a provision in the mining mineral concession rule for permission of stock, for stocking permission of sand.
My lord,
And it was rightly pointed out that.
well,
when
one
this
thing is very clear.
notification was in,
Supreme Court is very candid.
Was transit pass issued for this period?
he never applied for it. And the
What will apply?
period when
Otherwise,
this
did you mention in
notification
your
was
order?
force,
Sir, then for I'm rejecting. What they cannot, my lord, from the order, they cannot debate. By affidavit, they cannot improve. What is there, that is there. Nothing is appeared from the order. All these things.
Affidavits are not required. Let them come back with a report because they're
Very well, my lord.
the authorities.
Very well, my lord.
The petitioner affidavit of service. The petitioner has assailed the order passed by the Assistant Secretary, Department of Industry and Commerce, Department of Industry, Commerce and Enterprises on 10th April 2023.
Yeah.
Turning down the prayer of the petitioner for extension of mining lease. Stop. Paragraph is submitted on behalf of the petitioner that the petitioner was unable to carry on mining operation from 25th March 2021 to 22nd February 2022 in view of the notification of the district magistrate and collector, Purbo Bardhaman, restricting movement of all kinds of heavy loaded goods vehicles through the road approaching the plots in question. Stop. The restriction was withdrawn by a notification issued on 22nd February 2022. Paragraph.
Add to that email representation for opening that road because order says no representation is made.
Petitioner
Page 100.
Submitted a representation before the
Appropriate authority, my lord.
district magistrate, Purbo Bardhaman, requesting reopening of the road in order to enable the petitioner to continue with mining operations. Paragraph. Per contra, learned counsels for the respondents submits that the notification in question was issued for the district of Purva Bardhaman and could not have affected mining operations of the petitioner. Paragraph, learned counsels seek to submit reports in the form of affidavit in this regard.
Well, one thing is
Paragraph-
very clear, my lord, in reply to the arguments, my lord is recording the order. They cannot improve by producing something else which is not deflected from the order. Kindly record
Let
it.
them come back, let them.
As-
come
as
back.
well as- Order is saying something.
Here under the same heading on 13 June.
13.
Yes,
Why is- Arey bhai, why is-
very well, come back on 16 June.
I am being unconditional. ধুত্তরি কি হচ্ছে?
16 June. Please serve advance copy.
হ্যাঁ, একদম। Let it be recorded, my authorities, my lord.
Reports
just
in the
a
form of affidavit be submitted on the adjourned date upon service of advance copy to the petitioner. Yes, next matter.
86. May I leave, my lord?
18,
I am the petitioner. This matter is somewhat similar to the previous matter, although at the nascent stage, my lord. Petitioner will not obtain a lease, mining lease for sand mining in 2018. Now, there is a similar clause, my lord, as pointed out in the previous matter, my lord, which says that if there is not any force majeure incident which will not precludes him from carrying on mining, that shall be excluded. That clause is at page 119. Clause 5, last few lines,
119,
119. Clause 5,
clause 5, yes.
now the last few lines, I'm not reading, my lord. So, my lord, this, under this clause, it started from the 23rd of April 2018 for 5 years. Normally, it ends on the 22nd of April 2023. Now, my lord, the COVID intervened. There were lockdowns, there were, my lord, restrictions, could not carry on. There were several other, my lord, eventualities also. He made a comprehensive representation at page 133, pointing out whatever as per us is the, my lord, event of force majeure. 133.
Yes.
Annexure P4 made on 9th of January 2023. This application, my lord, they have not yet decided. In the meantime, my lord, the period, my lord, was till 22nd of April. So, my lord, today we are in possession, but after 22nd April, we cannot, my lord, carry on mining. This is the position. So, our, my lord, twofold prayer. One is, my lord, let the representation, my lord, be considered by considering the force majeure clause and my reasons cited in my representation. And in the meantime, let them not disturb us because we are in possession. So let them give a time frame within which they have to take a decision after giving us hearing. In the meantime, let them not disturb us. Now, this is my limited prayer, my lord.
Yes,
Yes, 33, my lord, prayer of the
page 33. Yes, that is his prayer. And during pendency of the representation, no coercive action. Because you are still in possession.
I am in possession.
Mr. Shah, you don't. Yes, right. Heard affidavit of service, heard learned counsels for the parties. It is contended on behalf of the petitioner that the petitioner was granted. Yes, that is a submission. Was granted long-term mining lease for a period of 5 years with a deed of lease.
Page 86, my lord. 23rd April, 86.
What is the date of the deed?
23rd of April 2018.
Dated 23rd April 2018, which has expired on 22nd April 2023. Stop. The petitioner was unable to carry on mining operation due to the COVID-19 pandemic and other factors for which he filed a representation before the concerned authority on 9th January 2023 for extension of the period of lease. Paragraph, learned counsel for the petitioner has taken this court to clause 5 of part Roman 9 of the deed of lease, which demonstrates that if through force majeure, the fulfillment by the lessee of any of the terms and conditions of the lease be delayed, comma, the period of such delay shall be added to the period fixed by this lease. Paragraph, the petitioner prays for a direction upon the authority to consider his representation in the light of clause 5 of part Roman 9 of the deed. Paragraph, it is submitted on behalf of the respondents that the district magistrate should consider seventh respondent. The seventh respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the seventh respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing, yes, little more time, 6 weeks, within 6 weeks. Opportunity of hearing to all the interested persons, including the petitioner, and in the light of clause 5 of Roman 9 of the deed of lease, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, pending disposal of the representation, comma, no coercive step be taken by the respondents against the petitioner in respect of the plot, which is the subject matter of the writ petition. Petitioner's submission act line add করুন, it is also submitted, petitioner's submission, that the plot in question is still in possession of the petitioner. Yes,
19.
Milord, 19 to 28 is same almost.
19
Now,
to 28,
28.
yes.
Now, Milord, the note. Yes. Mr. Yes, Chatterjee is coming, Milord, and he asked me to start, Milord, so for us. Milord, two questions, Milord, principally, Milord, have arisen for consideration. One is whether I'm entitled to seek a stay of your lordship's order in a writ petition wherein, Milord, my clients were not made party. Number one. Number two, Milord, if demands of in order which I question in this writ petition, Milord, there are twofold challenge. One is inaction on the part of the respondents in not, Milord, disposing the sands, Milord, that were stacked in the land, Milord, in terms of the relevant rules, Milord, and we were the successful bidders, and there are 73 plots, Milord, from which, Milord, the seized article, that means sands or the confiscated sands, Milord, were supposed to be auctioned. Now, the private respondent, Milord, who filed 2 writ petitions before your lordships, in which the interim order was passed, I take my lord's kind attention to that order first. That is at page 3, P3. P3. Milord, I request your lordship, Milord, to take, Milord, item number 20 first, if it commences your lordship.
Item number 20.
20. Oh, this also same. 54. 54, Milord, page.
The order?
Order. 58 to 60. Right. Your lordship is
58 is an order in
51.
58 and 61. There are 2 writ petition orders.
19. 98. Thank you. 58, Milord. Your lordship is
Yes.
right. I am wrong.
Yes.
58, Milord. And now affidavit of service. None appears for the state. Mr. Chandicharan, who usually appears for the state and is present in court, is requested to represent the state in the matter. His appointment be regular, as I am skipping up. Next, the petitioner has prayed for a writ in the nature of mandamus, directing the respondents to quash, cancel and withdraw the impugned order dated 8 December 2022 and consider the representation submitted by the petitioner dated 5th September 2022. Pursuant to an order passed by this court in WPA number such and such on 21st November, directing the respondents to consider and dispose of the representation submitted by the petitioner herein, the order impugned was passed by the additional district magistrate and district land reforms officer Purba Bardhaman on 8 December 2022, whereby the representation submitted by the petitioner was rejected with a direction for auction of the surplus and sand seized from the sand block allotted to the petitioner. It is submitted on behalf of the petitioner that there is no provision for auction of surplus land in the Mines and Minerals Development Regulation Act 1957 or the West Bengal Minor Mineral Concession Rules 2016. Per contra, it is submitted on behalf of the respondents that the prayer made by the petitioner is beyond pleadings and therefore cannot be considered. Learned Counsel seeks to submit a report in the form of affidavit in this matter. Since the legality and validity of a notice of auction dated 8 December 2022 has been assailed, and Learned Counsel for respondent has not been able to apprise the court as to under which provision of law such notice was issued, the notice of auction dated 8 December 2022 be stayed until further orders. Now, my lord, my writ petitions which are pending before your lordships now taking up for consideration. I am seeking stay of your lordship's order, whether it is permissible from the same court to which I am set to satisfy. I am armed with two decisions. One is of the Supreme Court, 1963, 1909, paragraph 8. Following that, your lordship's court special bench consisted of 3 honorable judges, followed that principle of law. When and under what circumstances the court can stay its own orders, number one. And review also. It's a kind of review in a petition couched under Article 226. Second part, the inaction, because your lordship was induced to believe that the rules are silent with regard to the auction because that is the only premise. I take my lord's kind attention first to the rule, and second, whether I'm entitled to make such prayer, staying the operation of the order. And then pleading only 4 paragraphs. Judge Sahib ko do.
It was stayed on 2 counts, not only the rules.
No, I'm
Since
staying.
the order itself is anti-challenge.
Order?
It was stayed on 2 counts.
Yes.
Firstly, the learned counsel could not apprise the court as to whether there is any provision. And the other ground is since legality and validity of the notice has been assailed.
Assailed.
So it is not only that there was no
but
place of
notice has
provision.
been assailed because the notice seeking auction is impermissible. If the rules provide auction, then the legality of the notice, Millard, would become lightened because the notice, why it is illegal? Because the notice says that the seized sand, Millard, has to be disposed of through auction. Now, if the auction is not impermissible, and rules do not provide, which the court believe, and third, the most important, Millard, the writ petitioner, possibly, Millard, by mistake, omitted to tell your lordship that there are 73 Millard plots in respect of which the auctions were, Millard, and there are specific identification number with regard to the each and every sand miners. Now, question is, the writ as filed by Mr. Chatterjee, my learned esteemed friend's client, are confined to a particular plot which is in respect of their specific identification number. The claim or the right as alleged to have been claimed in the writ petition cannot be, Millard, so omnibus that it covers the entire zone. And number one. Number two, had it been thing that it covers, then, Millard, we should have been implicated as a party since we became the successful auction on the day. So the stay, suppose if it is validly passed, I presume that this particular auction is confined to his land where his identifications are related, then I do not have any objection because the state is not disposed, despite being, Millard, a successful bidder, despite that I have, Millard, deposited the amount which in terms of, Millard, the auction notice. Now I am to satisfy your lordship 3. First, Millard, that if such prayer is stayed or allowed partially, then Mr. Chatterjee's client would not be prejudiced legally. Second, that there are 73 plots, whether it was disclosed to your lordships. Lordship, and third, my lord, whether in a read petition, I can, my lord, ask for and seek for stay of operation of your lordship's own order where I was not a party. I come, my lord, first, my lord, from the last part of the order. This is the rule, my lord.
My lord, may I just point out three things, lordship?
I mean,
He has not
he will
completed.
he will get his chance, I
He has
understand.
not completed.
You complete.
He will get his chance.
Yes, Mr. Vice.
He will get it. Otherwise, my lord, because his personality otherwise supersede me. Judge সাহেবকে দিয়েছেন?
Yes.
My lord, this rule is known as, my lord, the West Bengal Mineral Concession Rule 2016. My lord, the first page, the West Bengal Minor Mineral Concession Rules 2016. Has your lordship got it?
Yes.
Directly comes to, my lord, Rule 50, Chapter 10, page 442. Rule 50. আরেকটা rule আছে, বার কর। অন্যদিকে তাকাস না। ওই ছেলেটাকে 50.
Yes.
Any person extracting any minor mineral without a proper lease or license granted under these rules, or storing or transporting such minor minerals extracted in an unauthorized manner shall be punishable with imprisonment for a term which may extend to 2 years, or with a fine which may extend to 1 lakh rupees or both. This is a penal provision. Kindly comes to, my lord, 3 and 4. Whenever any person removed without any lawful authority any minor mineral from any land for that purpose, brings on the land any tool, equipment, vehicle, or any other thing, such mineral, rule, equipment, vehicle, or other thing shall be liable to be seized by an officer or authority especially empowered in this behalf. 4. Any mineral, tool, equipment, vehicle, or any other thing seized under Sub-Rule 3 shall be liable to be confiscated by an order of the court competent to take cognizance of the offense, and shall be disposed of in accordance with the direction of such court. This was the rule, my lord, 2016 was prevalent. Now, my lord, by a flux of time, my lord, this new concession rule 2021, this is, my lord, West Bengal Sand Mining Transportation, Storage and Sales Rules 2021. Now, my lord, kindly comes to third page. Sub-Rule 3. May I start, my lord?
Yes.
Notwithstanding anything contained, applicability of these rules. Notwithstanding anything contained in the West Bengal Minor Mineral Concession Rules 2016, West Bengal Minor Minerals Auction Rules 2016, the West Bengal Minerals Prevention of Illegal Mining, Transport and Storage Rule 2002, and or any other rule for the time being in force in the state of West Bengal from the date of commencement of these rules shall be applicable for 1. Carrying out sand mining operation, regulating and monitoring sand mining operations, prevention of illegal sand mining operations, and for purpose connected therewith. It covers everything. It's a complete rules. It covers, my lord, even if the mining operations and all other purposes connected therewith. Even if, my lord, these purposes are not specified within 1, 2, 3, the 4, my lord, covers everything. Am I clear to, my lord?
Cannot be a blanket rule where. what are
No,
the other
I'm saying
purposes?
carrying applicability of this rule, my lord, it covers carrying out sand mining operation, regulating and monitoring and mining operations, prevention of illegal sand mining operations, and, my lord, so first 1, 2, 3 specific, and for purposes connected therewith means 1, 2, 3.
Yes, but it may or may not include auction of the surplus
Correct.
sand.
Yes.
Where is the
Auction, my
specific
lord.
provision?
Yes. 23. First, my lord, power to search.
Yes.
Second, my lord, the district level sand committee and state level committee has reasons to believe the provision of the rule have been contravened or likely to be contravened. It may direct authorized officer such and such document, place or things. If such authorized suo moto has reasons to believe that provision of these rules have been contravened, such authorized officer may search any sand, document, pass or things. The provision of section 100 of criminal procedure shall apply to every such search carried out under sub-rule 1 and 2. 25. This is important. Power to seize. Whenever any person carries out any sand mining operations or causes to be carried out, any sand mining operations without any lawful authority, and for that purpose uses any tool, equipment, carrier, or any other thing which includes property, such property shall be liable to be seized by the authorized officer. Every authorized officer seizing any property under this rule shall photograph the property and place such property or mark in such a manner. I'm skipping over. The property may be released upon payment of applicable amount as may be specified by state government is a notification public in such and such. The applicable amount for release of property shall be paid within such and such on the date of knowledge of the seizure. If the same property is seized more than one time under this rule, may be released only on payment of a less 50% of the showroom value of property. If the specified amount is not duly paid within the specified time, the authority specified by the state government by notification published in the official gazette may confiscate and auction such property. Am I clear? So first his condition is search and seizure. Second is confiscation or seize. And if is a seed then the power to auction by reason of 2022 rules. 2016 has to be read in the context that is in not derogation of and in addition to. Your lordship has taught us whenever your lordship had the occasion to take section 151 there was a famous saying that it is in addition but not in derogation of the Code of Civil Procedure.
Yes.
So that is what আমি পড়লাম 25 নম্বর ধারা উপধারাটা 3 4 পেয়েছো এটা 22 এর রুলটা পেয়েছো West Bengal Sand Mining Transportation Rule 2021 পেয়েছো So first of all, your lordship was induced to believe that in absence of rule, the notice, stipulates auction, that is, the first illegality.
Yes.
Second, the balance of convenience and inconvenience is a primary factor, while the court, passes an ad interim injunction, it is the basic concept. Now, if I take my lord's kind attention to paragraph 5 first of this writ petition, sorry, page 4, paragraph 4. First of all, it depicts the entitlement. Your petitioner states that the petitioner participated in the auction process and placed his bid in respect of auction ID being number such and such, and the petitioner became the highest bidder. Number is 2681. Identification number is most important thing, in order to specify the target. So, I enclose bidding documents and I take my lord's kind attention to start from paragraph 5. Your petitioner states that the petitioner came to know that the respondent number 5 and 6 preferred two writ petitions being number such and such. In the said writ petition, the respondent number 5 and 6 assailed the action of the respondent in auctioning the sand of the respondent number such and such. It is pertinent to mention here the sand of the respondent number 5 and 6 were included at serial number 42 and 3 of the auction notice dated 18/10/2022, having auction ID 2704. Am I clear? And 2665 respectively. And the petitioner has not placed his bid in respect of those auction IDs. On 21 December 2022, these petitions came up before your lordship, and after hearing her ladyship was pleased to stay the auction process. I read for my lord because that is the order. I said, the petitioner was not a party to the said writ petition, nor the petitioner is a contending bidder in respect of the auction number which Mr. Chatterjee, my learned esteemed friends, clients are contesting, containing the sand of the respondent number 5 and 6. However, due to the blanket order of stay, they enter onto a process and the petitioner is aggrieved. Now, the petitioner state the petitioner approached the respondent authority concerned by submitting a petition for our issuance of the disposal of the sand against auction ID number 2681. Since the petitioner is a successful H1 bidder, the petitioner was verbally informed by the district authority concerned that in view of the order passed in those writ petition, it is not possible for the district authority to issue order of disposal in respect of the auction ID number such and such, despite the fact that the subject matter of those two petitions are auction IDs number 2704 and 2665 respectively. Your petitioner submits that the petitioner has to purchase it as on his where is basis. The sand is lying on the auction as mentioned in the bid document, and the same will be damaged in the rains of pre-monsoon and monsoon seasons, as there will be growth of vegetation over the said sand due to moisture and temperature. I submit that petitioner has to purchase it on as is where is basis, and petitioner may not get the best value for the same if the same gets damaged with the passage of time. In paragraph 10, my lord, I said, my lord, that as such, the petitioner could not get any opportunity to submit before the honorable court that the subject matter of the said writ petitioner concerning the sand, again, my lord, I have specified my number, and my lord, 11, I said, my lord, the petitioner, that is Mr. Chatterjee's, my learned friend's client, my lord, has no claim, rival claim, my lord, so far as my claim is concerned, I have no rival claim against Mr. Chatterjee's client. And 12 is very specific. I said, my lord, in the third paragraph, third line, as such, the petitioner could not get an opportunity to submit before the honorable court. There are total 73 auction IDs in the impugned auction process, and the petitioner there are only concerned with 2 IDs, serial number 42, which I mentioned, my lord, in paragraph, and the ID numbers are specific. Now, my lord, the question is, even if this is a situation, whether the court is authorized to stay its own order, and more particularly, if the order is even vacated or modified, order 39 rule 4, then my lord, question is that how does it affect Mr. Chatterjee's client? Now, my lord, the first judgment is reported in EIR 63, Supreme Court 1909, pay paragraph number 8. 1909. The petitioner, paragraph 8, my lord.
Paragraph 8.
May I read? The other contention of Mr. Gopal Singh pertains to the second order of Khoshla J, which in effect reviews his prior order. Learned counsel contends that Article 226 of the Constitution does not confer any power on the High Court to review its own order, and therefore the second order of Khoshla J was without jurisdiction. Without jurisdiction, it is sufficient to say that there is nothing in Article 226 of the Constitution to preclude a High Court from exercising the power of review, which inheres in every court of plenary jurisdiction, to prevent miscarriage of justice or to correct grave and palpable errors committed by it. Here, the previous order of Khoshla J affected the interest of the persons who were not made parties to the proceedings before him. It was at their instance and for made parties to the it was at their instance and for giving them a hearing that Khoshla J entertained the second petition. In doing so, he merely did not what the principle of natural justice required him to do so. It is said that respondents before us had no right to apply for review because they were not parties to the previous proceeding. As we have already pointed out, it is precisely because they were not paid parties to the previous proceedings, though their interest was sought to be affected by the decision of the High Court, that the second application was entertained by Khoshla J. We therefore dismiss the appeal. The law is very clear, no uncertainty, no vagueness. Now, my lord, your lordship's court, my lord, they reported in 1988, 2 CHN 276, 1998, 2 CHN 276, my lord. My lord, 3 honorable judges, including the Chief Justice P.S. Mishra, Justice S.B. Sinha, Justice V.K. Gupta. Now, my lord, I take, my lord, paragraph 46, my lord, straightway.
Yes. Yes.
However, a fresh writ application at the instance of a third party to review order passed by the court is maintainable in terms of Article 226 of the Constitution of India in view of the decision of the Supreme Court in Shivdev Singh for the state of Punjab reported in EIR 63-1909. So your lordship's High Court has followed, my lord, the Supreme Court, my lord.
Yes.
Yes, my lord. So, my lord, my first submission is this, my lord, that the rules are specific, empowering them. Second, I can seek an operation of stay of operation of this order passed by your lordship, or in the alternative, vacating, modifying everything. Now, my lord, third, that the court on the first day, my lord, the court was induced to believe that the auction notice is palpably bad. Challenge was thrown to the notice only on the score, my lord. The premise of the writ petition which court has, my lord, recorded in no uncertain terms, that in absence of the rule, how could you do it? Now the rule which permitting them to auction, my lord, of a seized and confiscated properties has not been questioned by making a prayer that these rules are ultra vires. So, my lord, in absence of specific challenge thrown to the rule, fourth, my lord, that whether the withholding of the auction and the state which maintains angelic silence in disposing of the sands, my lord, in respect of those persons who are successful bidders and deposited the fees and have distinct and separate identities, IDs, my lord, which is identifiable, my lord, whether the state can withhold for the public interest, because it is synonymous with the losing of the revenue. State could earn, and at the same time, my lord, when state, my lord, makes a provision for the citizen for earning, my lord, the state cannot be allowed to be unjustly enriched by reason of taking my money, and my lord, it keeps it in the bank and, my lord, enjoying the interest. But I am the loser because I cannot prevent rain, my lord. And under these circumstances, my lord, without going to, my lord, the forensic conflict and anything, my lord, I can say, my lord, with humility, subject to what my lord will say, and Mr. Chatterjee, my learned friend, my lord, and the other friends representing the state, my lord, if the order is modified, that state can go for an auction, keeping these two IDs, my lord, because he has challenged, so that then, my lord, I can get. So without, my lord, causing any injury, my lord, to my learned friend, approach.
Approach the relief at this stage. Let us hear the state.
My lord, I have basic objections, preliminary objections to my friend's writ petition on the score that this writ petition, by filing this writ petition, he is seeking an interim order which is touching the rights which has been
Seeking a final order, not an
final
interim
order.
order at all.
Now he may seek for a final order touching the rights which has been accrued by my client by filing another writ petition which is not on board today. So, Lordship, I request your Lordship to take the writ petition on board and hold the analogous hearing of both. Now, Lordship, second, my argument will be on this.
The
those
other
things-
before you proceed, the other petition is confined to your ID only.
This is not confined to my ID. There are challenges which was thrown to the notifications directing the auctions of the sand belonging to my client. The notification had the same memo number which was challenged, and Lordship was of the view that where is the power of the auction of those materials which are seized or not seized. Even in my case, there was no seizure which was properly done. That was the fact. Now, Lordship, my learned senior friend's claim is based on the rule. He is showing the rule. He is showing Rule 25, Clause 3. Rule 25, Clause 3, which talks about power to seize. It says, whenever any person carries out any sand mining operations or causes to be carried out any sand mining operations without any lawful authority and for the purpose, uses any tool, equipment, carrier, or any other thing, property, such property shall be liable to be seized by the authorized officer. Now, Lordship 3 says, the property may be released upon payment of applicable amounts as may be specified by the state government in a notification published in the official gazette. 4, the applicable amount of the release of the property shall be paid within 1 month from the date of knowledge of the seizure. If the same property is seized more than one time under this rule, it may be released only on payment of at least 50% of the showroom value of the property. If the specified amount is not duly paid within the specified time, the authority specified by the state government by notification published may confiscate and auction such property. So, Lordship, auction comes as result of the preceding factors like confiscation prior to that seizure, prior to that option to the owner of the property to make the payment of royalty, payment of other values which are created, at least at per the showroom value. Now, Lordship, in this case, nothing was done. Even we made several requests to the authority that we are ready to pay the royalty if it is calculated, we are ready to pay. But our case was based on the premise that we were not given those options. Directly, straight away, they have issued the notice for auction of the property. Therefore, that was the order which Mr. Basu is seeking to be stayed and seeking to be quashed by this petition. That is, Lordship, the order number. Kindly come to the memo number 28300 is my writ petition number, and the order, Lordship, is annexed in my writ petition was in my writ petition, the order has to be examined, Lordship, before. It's item number 94. It is on board today. My writ petition. The same memo number is there. And number 2, Lordship, in case where we say that there was no seizure, there was no identification of the property. It was just directly notified that your property has to be auctioned by the authority. There was no option given to us for the payment of royalty. So this was done. So, Lordship, if any order is passed today, then that will prejudice my client. Now, Lordship, kindly come to the rule. This, on the last occasion when your Lordship wanted me to satisfy your Lordship whether there is any rule for the auction, it was found that there was no rule for the auction, and it is
sought in the earlier writ petition filed by you is confined to your property, your ID.
yes, and I say my property is
Beyond that.
my property is covered by that memo which Mr. Basu want to be quashed today.
Yes, but that memo covers other, he's not asking for quashing of the memo. He's asking for modification of this order
Because that memo covers that memo covers my property
also,
also.
besides all other properties. Isn't it?
Now this is, Lordship, kindly come.
So you can ask for relief only in respect of your property, not beyond.
Lordship, now, Lordship,
So
this
how
is,
will you
now,
set
Lordship, the
this?
date is that now state this authority when, kindly come to the date of the order of auction, when it was conducted. Now, that is why
Let us not go into the merits of.
the merit is
auction or
important, because
purpose of the
your
same.
Lordship has issued the interim order on that day. That day itself, the order of auction was issued. It's a violation of your Lordship's order. First, that has to be checked by them.
Have you come up before this court in contempt?
Yes, contempt has been filed. We have given the notice of the contempt, and it is where we.
That will be dealt with separately.
The order was not served. We have communicated the order
That will be dealt with separately, sir.
on the
You have
same
not
day.
come up in contempt.
Matter is appearing as item number 95, Lordship. I'll
The writ petition. That's the writ petition.
read petition and we'll come up with
Your
this.
writ petition will be dealt with on merits separately,
Kindly
sir. Don't
come to
worry.
Lordship, the writ petition memo number 821 MM22 dated 18/10/2022. This was the memo.
Memo?
821/MM/22 dated 18/10/2022.
Yes.
Let this memo not be touched. Kindly see the memo. It's the previous writ petition, Lordship. Kindly see the memo. This was taken. This action was taken. Let the ADMLR come before your Lordship and explain. And the petition is still pending. Why should I file a contempt? And why are you so much conscious about it? ADMLR ke বাঁচানোর জন্য this was communicated by us.
Immediately, within 30 minutes.
This notice was under challenge in your
Yes,
petition.
it was stayed. The action was arising out of this notice, Lordship. That's why I'm making this submission. Lordship, take our writ petitions analogously. Fix this tomorrow and then Lordship hear it out. Otherwise, Lordship, my rights would be prejudiced, highly prejudiced. They want to modify the order passed in my writ petition. And when the writ
To the
petition is,
extent that it will be.
now the question is, still the writ petition is there in the list. Lordship, kindly take up the writ petition. I don't know, I am aggrieved because it is touching my right.
Please.
Because the court also says that your Lordship can only interfere, modify whatsoever your Lordship may pass any order to that extent, if that is a challenge to the miscarriage of justice. In that case, only your Lordship may intervene. Now, if this petition is there and today your Lordship passes any order without examining that, that is going to.
Sir, you agree that this this notification covers the rights of the petitioner?
I do not agree. I do not agree. I came to see after this writ petition is filed. Your Lordship, kindly come examine my writ petition.
Let me change the term. You are aware that it touches the rights of the petitioners in all these writ petitions?
I am aware that it is touching my rights. I am not aware because I am not
Not
considered.
the rights of anyone else's?
It's touching my rights.
Insofar as it is
Milord, he is a
touching
junior
non-rights.
member of the bar. I do not wish, Milord, because I respect his spirit, Milord. But such spirit should not, Milord, go beyond the records, because I know that he has earned respect, and by this time at the bar, he should not. It is my duty as a senior, Milord, to guide my junior, even if in the adversarial form. Milord, if he looks into, Milord, my own brief, he will be unhesitatingly admitted that all others players are there.
No, it is touching my rights. I am not concerned with the
No,
others,
he
but I
said,
am
Milord,
touching with
I
my
tell your
rights.
Lordship,
If I say
Milord,
that-
when court makes a query, the answer should be specific.
No,
Your
no.
Lordship's query was that whether he is aware that these notices, this particular notice which he has questioned, whether it covers other person's right. Now, my answer
No.
to his answer should be to the court
Notice
that
is there before your Lordship.
that
Kindly
schedule
see-
of the sand stock kindly comes to
kindly see
page
the notice which
kindly
was communicated to me.
30 of my petition. Which
Kindly
your
come-
Lordship is considering. Milord,
30 is all the blocks.
all the blocks, and Milord, 30, total number is 73. I have mentioned.
Annex the notice of.
Yes. Notice is, Milord, page 19.
Corrigendum to it.
Page 19.
41 is the notice.
Yes. Page
Number is not mentioned, Lordship.
19. So Mr. Chatterjee's client, Milord, notice is hereby given, page 19, for auction of bona fide individuals, firms and companies. Milord, বার করে দিন না, 19 নম্বর পাতা।
Yes, page 19.
Yes, 19, and kindly come straightway to page 30.
No, this is the rule.
Milord,
how
state,
the auction
no,
will be done.
no, the state, Milord, schedule of sand stock of the district or Purva Bardhaman to be auctioned. State has clearly stated schedule of sand stock. I am clear. Am I clear? Then, Milord, the number of the block. What more could be done by the state? I could
Now,
this
kindly
question to
see the
myself.
notification which I have challenged.
Then, page 40, kindly sees. There are 73 blocks.
73 blocks.
Did Mr. Chatterjee, can Mr. Chatterjee now say and feign ignorance that he was like an Alice in Wonderland and he could not understand the notice? It was in a fragmented.
No,
copy.
Lordship, kindly, may I get it? Lordship wants.
ওরম
Yes,
করিস
the
না।
same notice is annexed
Same
here.
notice, বাবা, আমি
28th of.
কোনো
Page 19 and
কাটতে হয়নি।
28, Lordship has not seen, Lordship.
It's a corrigendum to the original.
Yes,
Now,
corrigendum.
now, corrigendum to that notice.
No, was
Lordship,
the court informed at the time of
This
moving? First of all, Milord, the court was induced to believe.
Notice is 18th October.
Even then,
Yes.
Milord, I am saying that the order may be modified. I never stayed Milord the final relief. What is his prevention when there was suppression of material facts?
What, there is no suppression of.
Absolutely
material fact, my
suppression.
lord. Now, state is supporting, it's very unfortunate. Kindly come to page 87 once.
State is a welfare state. It
Yes,
can support
welfare
its
state
own
wants to
citizen.
auction the sand and. Let me finish my submission, my lord.
Let us cut short the matter.
Let,
Your writ petition will be dealt with on merits on the
Lordship,
day it is taken up.
Lordship, then, Lordship, no
Your
order may be
rights will
passed in
not
touching
be
my writ
no order.
petition. How can your Lordship modify the writ petition, the order passed in my writ petition by filing another writ petition when that is in the list.
The Supreme Court says so.
Lordship, I say Supreme Court says so, your lordship can do that to prevent the miscarriage of justice. I beseech your lordship to consider the fact, if that item number 95 is taken up together, then how would the justice would be defeated?
The present petitioners have no interest whatsoever in item number 95.
So I do not have any interest in this item.
Your plots are concerned.
Yes, my lord, only thing is
They
that
are
let it be taken up
their
together. Let it be taken up together and
Unfortunately, let us not go into how it was done and why it was done. All the plots of the petitioners have been included in your writ petition.
yes. Now, lordship,
Simultaneously incorrect.
kindly consider the fact your lordship has passed an interim order in my favor. That petition is
That will
there in the
continue
list today.
So far as your ID is concerned, sir.
Now, lordship, kindly come to this
You
notice
defeated.
once. Kindly come to this notice once. We have challenged this particular notice. Kindly come to the memo number.
As your plot is concerned, you cannot go beyond that.
Lordship, kindly come
Right.
to once, lordship, kindly come for my satisfaction. Kindly come to the auction notice that is 87. That is 848 auction stock of 2022
Notice
dated
dated.
28/10/2022.
Notice dated.
28/10/2022.
Yes.
The portion of point number 12 of the bid document, an order to deposit the bidding amount within 7 days will be issued to the successful bidder after completion of bidding process. That was the last action on the basis of which we have challenged. Order for depositing the 1/3 of the total amount within 7 days will be issued to the successful bidder after completion of the bidding process. Remaining amount shall be paid to two equal installments within 30 days and 60 days respectively, or before disposal of the corresponding stock, whichever is earlier. No bidder can dispose stock quantum more than the corresponding portion of the installment he has made at the point of the time. Failure to deposit any installment within specified timeline will authorize the chairperson of DCCB to cancel the bid award. Now, this was the notice, the last action which was challenged. Prior to that, your lordship passed the notice dated 28/10/2022. Now, lordship, kindly come to the notice which has been assailed by Mr. Basu's client. That is page 19. This is the notice hereby given to the e-auction firm bona fide individuals, firms and companies for one-time disposal of excess of unauthorized stock of sand only through online mode of competitive bidding in the government e-auction system. Now, lordship, this may have the list. However, this is the same instrument on the basis of which I am challenging my
Where
claim.
has this notice been challenged in the writ petition? This notice has not
The
been
entire
challenged.
document is under challenge because this is the outcome of this.
It is challenged in your writ
They
petition,
are
but not
doing
in
this bidding
petition.
process out of this particular notification.
It is
Now,
not
if your
challenged
lordship
in
today
these
decides,
petitions.
that was challenged in the writ petition.
No,
This notice was challenged in my.
Your petition, not in these writ petitions.
Not in this
So
petition.
that's why, lordship, it's going to touch my rights also.
You have just submitted that Mr. Basu's writ petitions challenge these notices. No.
No, kindly come.
That's
This notice is the creature of this particular notice, that is 18/10/2020.
Your rights will be kept intact, sir,
Now, lordship,
and will be decided in your writ petition.
now today, lordship, your lordship is also examining one issue, that whether they have the auction power. I have shown one judgment on.
At all.
I have shown
Issue
one
is not
judgment on the
being
last.
At all in this writ petition.
No, lordship, may.
No, Milord, he
Now
has to
today-
submit to
Correct
correction.
submittance, sir.
No,
This
in
issue
my
is
writ
not being
petition,
decided
in
in
my
this
writ petition, lordship,
Please
that
confine your argument to this writ petition.
I am, lordship, the question is my,
Your
lordship,
writ petition will be dealt with separately.
let it be taken up together
Why?
Not
to cut
necessary.
short the entire issue.
Why?
Necessary.
Otherwise, it is going to touch. Why it is going to touch?
Your client
Let
did
me
not.
finish, Mr. Basu.
your
I will
client-
not interfere when you have
No, no,
submitted.
I respect your.
I also respect.
Mr.
That's
Basu,
why
let
I
us
did
hear
not.
what he has to say. Yes.
In item number 94, I have challenged the notice
Yes.
of auction of my property.
Were you entitled to challenge the notice in respect of other IDs also?
No, but
You have done
lordship,
that.
my challenge
done
is
that.
based on My challenge was based on the fact that they do not have the power of auction under the present statutory scheme. That was the ground. Now, if today your lordship decides that they are entitled to get the sand released by today's order, can your lordship tomorrow differ from your lordship's view in that writ petition if it is taken up? I'm asking this question to myself.
It will,
So
that part will not be decided here at all,
now
sir. because
today,
that
if
has
your
not been
lordship,
asked for.
if your lordship directs for the release today,
I
if
am
your-
not directing the release, sir, please understand. No direction for release is going to be granted in this writ petition. Only the remaining part of the plots will be excluded from your writ petition.
Yes.
Because your writ petition pertains to your plot only.
Yes.
You cannot include all other plots in
No,
your writ petition.
I am because
Please do
I,
not make it
now
complicated.
lordship, my writ petition, we have challenged the power of auction. We categorically said this statute do not provide the power of auction.
Which is untrue, incorrect.
I say it is true. Mr. Basu's submission is not true, untrue. Now, that is my issue.
not my
Now,
issue.
that's the thing. That's the thing. Today, if it is decided in his favor today,
He has decided
I
not to
will-
understand your lordship's
my
language.
right to challenge will be seized in respect of the power of the auction. I challenge, I said that the state do not have any power to auction in this particular
Yes, Millard,
case.
I am extremely grateful to my learned friend. Kindly ask him, Millard, subject to correction, that whether petition 95 says 94, his petition, Millard, whether it says that beyond these two identification number, beyond these two plots, whether he has a claim. And if he has a claim, the revenue which his government is going to lose and losing each day, Millard, the principle of injunction, the entire financial loss supported
Yes.
by the client, whether he had made the submission on the first day that he was ready and willing to the entire revenue which is expected to be generated
No,
by the
this
government.
is not a revenue in my humble submission. That was my argument.
Challenge.
Lordship,
He has not challenged.
Investigation.
He has not challenged.
Lordship, I have challenged the
Millard,
power
he
because
will
their
know.
action. I say
He may
they
have.
do not have the power to auction.
Even if you have challenged the power of auction, that is with regard to your land. It's
Yes,
not a public interest.
he cannot
litigation.
travel beyond his
Now,
power.
if
Court.
today, if your lordship
Really?
decides, I'm asking this question to myself, if today your lordship decides that there is power of auction,
This will
and
not be decided, sir.
Millard, he is again Millard misunderstood, conscious misunderstanding.
Decided in
He
this.
has consciously
order will
misunderstood.
be conflicting.
No,
Order will be conflicting.
no.
Order will be
Not at all.
conflicting, lordship.
No.
Lordship, order will be conflicting.
Millard,
Why? I'm
suppose
saying
tomorrow,
that
Millard,
today,
Millard,
if your
absolutely.
lordship decides that
Yes.
it would be released
Yes.
to Mr. Basu's client, if it is decided
if it
today,
is.
by your lordship,
That will also not be the order, sir. I
Yes.
will only confine your writ petition to your land.
And
That's all.
yes.
More, nothing less.
now lordship, the kindly see,
Blanket
kindly
orders
see
on
the approach,
plots.
kindly see the approach, then lordship kindly consider my,
Anything
the
else to
same day,
Anything else to add?
same day when your lordship passed the order was communicated, this ADMLR has passed this order.
Maybe.
No, that's a contempt, clear contempt. I have given a notice.
That will be dealt as
Matter is on the
separately.
board. Matter is on the board. Matter is on the board, lordship. Why should I file a separate contempt application? Matter is on the board.
Sir, I'm sorry. Yes, anything.
Yes, yes.
Take up this matter. Kindly see that I wanted the matter to be heard analogously.
Not only that,
No, this,
He cannot be agreed.
if the state is aggrieved, the only thing, lordship, this is the tact is
I have
adopted
heard
by
you.
this.
I have heard you, sir.
Now, lordship,
Yes,
kindly.
Mr. Dhar.
no kind.
Mr. Dhar.
Every day.
This is not a revenue at all.
There will only be a modification to the extent that the writ petition will pertain to the other plots. Yes.
And
Anything to add?
number,
They have a plot. They have other plots.
My lord is not whether state has power.
No, not at all, not at all. That will be adjudicated with the other petitions.
That his right would be prejudiced. That is not right.
But in this matter, without hearing my writ petition, the entire thing will be prejudiced.
Your writ petition pertains to which plot, sir? All the 73 plots?
The notice is the same.
Maybe,
In one notice, there are several.
maybe,
plots,
maybe.
But the auction of the.
So you have to go before court number.
There is no mention in the notice.
Sir,
There is
I
no
have
mention
heard
of the
you.
plot,
Please, may I
Lordship.
request you to take your seat, sir.
Lordship, there is no
Yes.
mention in the of the plot in the notice.
The authority has been issued a one notice. There are several plots, but the notice is the same.
So can you file a writ petition in respect of all the 73 IDs? So then it becomes a public interest litigation?
The only notice is the one notice.
Maybe.
That's the source of the power, Lordship.
What is that?
That's the source of the power by which they have done it, Lordship. That's the thing.
Is there anything to add?
Now, the respondent of 5 and 6, operating authority challenge this requirement. As because my lord, as there is some only one point or two plots, my lord. That plot will be considered in that, but due to the cause of ourselves, that on that I was there, my lord. On the cause of myself, my lord, I was not mention this matter that this plot, this is only for the cause of the petitioner. Stay, you should be only for the cause of the petitioner.
No, Lordship, kindly, if your Lordship want to give them relief, kindly record my submission that I wanted this item number 94 to be heard it anonymously, Lordship. Kindly record my submission. Now, Lordship, and my stand should be secured.
Affidavit of service.
My stand should be secured and my right to question the power of auction.
Your
should be
case will
secured.
not be touched, sir.
And Lordship, kindly
Your
record that.
ID, your plot will not be touched.
Kindly, even my right to
I'll dictate the
challenge
order.
the power of
I'll dictate
auction,
the order.
Lordship, should not be touched.
Heard learned counsels for the affidavit of service. Heard learned counsels for the parties. The writ petitioners. কিসের analysis? না, না, আলাদা আলাদা হবে। একটাতেই writ petitioners. Oh, writ petitioner, actually. The writ petitioner has
Now, Lordship, my plots are also covered under this, Lordship, it should be excluded. It is also covered, my
It is
plots.
covered, sir. They have asked, they have said that only those plots are yours.
It's a part of their notice, Lordship. Put the notice to them.
The modification is to that extent. That
Lordship,
is their
kindly,
only
well,
prayer.
because it's.
And all these writ petitions can be disposed of by a common judge, common order. শুরুতে করুন।
Lordship, my plot is 120, that is
Since all the
eight this one,
restrictions-
3, house gum 3. Page number 20.
লেখা আছে রে বাবা প্যারাগ্রাফ 5 লেখা আছে
2704 and 2665, these are your IDs.
আইডেন্টিফিকেশন নাম্বার
Yes, and Lordship, the plots are there, since they have challenged it, kindly,
we have said plot number also in paragraph 5 I read. He did not lend his ears.
I have, Lordship, but why, what is the problem to go through this?
Problem is the wasting of time before vacation.
Not wasting of time before the vacation. You want to waste my property and you are saying that I'm wasting the time.
Your,
8200 plot.
you are concerned with 2704 and 2665,
820. Right,
not
Lordship,
beyond that.
820. 820.
82 আর কোনটা 82 আর কোনটা 82 এইটা একটা আরেকটা বলো নাম্বার কত
Since all these writ petitions,
বলো কোনটা বলো লোন নাম্বার
no, because since the common question of law and facts is involved in all the writ petitions, they are taken up for consideration and disposed of by a common order. তারপরে affidavit আছে। পেয়েছে কিনা দেখি নিন।
একটা আমার কোনটা তোমার একটা হরিনাপুর দুটো আছে একটা হচ্ছে 3261 আর হচ্ছে 26
Have prayed for review / modification of the orders passed in WPA number 27838 of 2022 and 28300 of 2022
এখানে করা আছে এন্টার এগ্রিমেন্টটা দেওয়া আছে
and submitted that the said orders be restricted to the auction IDs of private respondent numbers 5 and 6 and not beyond. Paragraph. It is submitted on behalf of the petitioners that
সিঙ্গেলটা মানে এই 3200 কত যেটা দিবে দেখা এই 3276
the notice of e-auction challenged in the said writ petitions filed by the private respondents pertains to 73 plots slash auction IDs, out of which the private respondents are concerned with 2 IDs being 2022 WB 2074 and 2022 WB 2665 respectively. Stop. The writ petitioners are holders of the remaining auction IDs and have prayed for exclusion of the said IDs from the orders passed in the earlier writ petitions, since these petitioners were not impleaded as parties therein. Paragraph. Learned Counsel further submits that the Rule 25 to auction the surplus sand, comma, which has been challenged in the earlier applications.
3 নম্বর সিরিয়াল আরেকটা আছে হরিনাথপুরে।
Learned counsels for the state respondents make their submissions in support of the contention made on behalf of the petitioners. Paragraph. I have heard learned counsels for the parties and considered the material on record, including the law on the point. Including the law on the point. Paragraph. The notification / corrigendum regarding e-auction of excess / unauthorized stock of sand dated 28th October 2022.
May take your lordship's kindly lordship.
This was challenged in your petition, isn't it? In the earlier petitions. Is under challenge in the earlier petitions. By orders. The earlier petitions filed by the private respondents pertain to auction ID 2022 WB 2704 and 2022 WB 2665 of the writ petitioners, and not all the 73 IDs included in the notification under challenge. Stop. By the orders passed in the earlier writ petitions on December 21, 2022 and 22, accurate, comma, this court granted an interim order in favor of the private respondents within bracket writ petitioners therein, bracket closed. Staying operation of the notice of auction. This is dated 8th December, the notice.
21st December 2022.
Notice of auction dated 8th December was stayed. Which is the 8th December notification?
8 December 2022 was
Yes, the 18th October notification was not challenged. This 8th December is challenged.
yes. That is the bid document, lordship.
That's the
Bid document they have said.
bid document.
This was the exercise
This
of
was
power
actually
and
stayed.
this was stayed.
যেটা under challenge বলেছি না ওটা 8th December 2022. 18th October বলেছি।
This is the e-auction process completely.
18th October বলেছি under challenge in the earlier 8th December 2022. In the earlier petitions. কি বললাম এবার last petitions. Notice of auction dated 8th December 2022. Stop. The said notice covers all the 73 plots of land / auction IDs, and not only that of the private respondents. Stop. The private respondents, being writ petitioners in the earlier writ petitions, comma, were entitled to relief only insofar as their auction IDs were concerned, and not in respect of the entire 73 plots / IDs. Stop. the blanket orders passed in the earlier writ petitions, touching upon all the 73 plots/IDs, is required to be modified to the extent that the said interim order shall pertain to the plots/IDs of the private respondents and no further. Paragraph.
The power of auction.
The Honorable Supreme Court, comma, in the authority in Shiv Deo Singh and others, within bracket SUVRA, has observed that there is nothing in Article 226 of the Constitution of India to preclude a High Court from exercising the power of review, which inheres in every court of plenary jurisdiction, to prevent miscarriage of justice or to correct grave and palpable errors committed by it. The same principle has been followed in the authority in Srimanto Kumar Mondol and others, within bracket SUPRA. Paragraph. In view of the above, comma, this court is inclined to hold that since the earlier writ petitions pertain to the plots/IDs of the private respondents, within bracket writ petitioners therein, bracket closed, comma, the interim order granted in favor of the private respondents ought to have been restricted to the plots/IDs of the private respondents and not the entire 73 plots/IDs. Stop. Comma, more so, comma, since the present writ petitioners were not impleaded as parties to the earlier writ petitions and therefore were deprived of an opportunity of hearing before the court.
Well, that was
Paragraph.
not possible for us to make them party.
Why? The remaining 71, that's fine.
How could, because there was no notice. Because my petition was
They
prior
should
to
have
the
been made
auction.
pro forma respondents at least.
I did not know because prior to the auction I came.
You had the list with you, sir.
No,
So you were aware.
No, not they. Lordship, the person who got the Mr. Basu's client, Lordship, it was not possible for me to identify who is Mr. Basu's client because my writ petition was prior to the auction takes place. Auction has taken place, and after that, Lordship, Mr. Basu's client has become the successful bidder and whatsoever. How would I know that who will be taking the auction? Because auction itself, action of auction itself was stayed by your Lordship's order. Action, Lordship, it should be pointed out before your Lordship for my clarity and for your Lordship's clarity. Your Lordship's interim order was passed prior to the auction.
I understand. So this
Now,
particular
Lordship, what has happened? Admittedly, it is the admitted position. It may be good for Mr. Basu's client, but it's very bad for the state because they admits that auction was held. Specifically, the auction was stayed by your Lordship's direction.
That's a different issue.
No, that's the thing.
Come back before the court.
No, Lordship, kindly record that. Kindly record that they says there was auction. They have kindly said that they have said.
Not made party, so
It is always your interest is my interest also.
The present petitioners claim to be the highest bidders. Petitioners claim to be the highest bidders in the auction held by the authority
Kindly write the date, Lordship. Auction.
and claim interest in respect of
Auction was
the
stayed by
remaining plots of land
Kindly record that.
covered by the
Yes.
covered by
And
the
that day only
petition
your
under
Lordship
challenge.
passed this order. And that was communicated.
Paragraph. In view of the above, the writ petitions are in view of
How
the
could
above,
it?
comma, the orders,
Auctionের date হচ্ছে 21/12/2022. Lordship, auction was held on 21st/12.
the same day, the same
Same
day,
date. Your Lordship passed that order on that day.
before the communication.
The auction was held, the time is there, communication was made.
That is actually not the subject matter of.
Now,
this
Lordship, that's
discussion.
the reason why I was
That
saying
we
that
dealt
is touching my rights. They knew the matter was on board. It was a leave matter. Notice was given to them. Thereafter, Lordship passed the order and they have
Sir,
done.
you are making your submissions of the other repetitions in this.
Because it's touching, Lordship, at the end of the day.
In view of the above, the orders dated December 21, 2022, passed in WPA 27838 of 2022 and 28300 of 2022 are modified to the extent that the notice of auction dated 8 December 2022, insofar as the petitioners therein / private respondents of these writ petitions are concerned, comma, bearing auction ID numbers 2022 WB 2704 and 2022 WB 2665 respectively, be stayed until further orders.
And Lordship, another thing, Lordship, petitioner is at liberty to take up all the issues, including the right to auction in that writ petition. Otherwise, Lordship, because tomorrow.
This order, paragraph, this order shall not preclude the petitioners.
No, Lordship,
the
preclude,
private
I have
respondents.
already entitled, not preclude. I am entitled, Lordship, it shall not touch prejudice any of the rights of the
Your
petitioner claim.
apprehensions, this order may preclude.
Because
That's fine.
tomorrow, Lordship,
That's
I am
fine.
saying so because
This order
tomorrow it
shall
may
not
change.
preclude the private respondents from raising the issue of
Lordship, which has already been raised, Lordship, and which has already been discussed by your Lordship, because in that order, there is a right created in my favor by staying the action of auction,
raising the issues which are already part of the earlier writ petitions.
including
when
auction,
the,
Lordship.
when the said writ petitions are taken up for consideration.
Including that auction, Lordship, kindly mention. Otherwise, Lordship, what?
The issues, why auction, everything.
Because auction was stayed by your Lordship. Why I'm saying so, since the order is passed. Now, tomorrow, this bench may be changed. Now, Lordship, they will take up this issue. State will come up with this issue, Lordship, saying that there was no reflection. Lordship, kindly record
This is sufficient reflection. I will not reflect the auction here. Dispose
So-
of.
Lordship, preclude instead of word preclude, it should not prejudice, Lordship. Preclude is something which I have not raised. It's already raised. It is adjudicated and interim relief has been given. Lordship, so I insist, your Lordship. I don't know why are you raising this objection.
Not been adjudicated.
I'm a
it will be adjudicated.
Lordship, that's why I'm saying, Lordship, instead of word preclude, Lordship, kindly, if your Lordship consider, kindly, instead of Lordship preclude, your Lordship kindly use the word prejudice. It shall not, because already the right has been created. It may be prima facie opinion of your Lordship.
Preclude is the appropriate word. Preclude is the appropriate word.
Lordship, it should not be instead of preclude.
That observation is protecting perhaps Mr. Chatterjee's client.
Absolutely.
Not perhaps, absolutely. Absolutely.
When we,
Yes, next.
Absolutely. I'm deeply obliged. Miller, affidavit of service are kept on record, Miller.
In all the matters you have given separate, sir. Yes. So this is still 28. 29.
and Lordship, your Lordship has taken this point, Lordship, that I have raised that 94 should be taken up with this. Lordship. Otherwise, I will be informed. Lordship.
Same order. Common order.
Lordship, I will be
Common
in,
Respondent submission, private respondent submission, Actal and Adkoru. Learned counsel. Learned counsel for the private counsels for the private respondent, 5 and 6. Learned counsels for the private respondents seek for consideration of these matters along with the earlier repetitions. একটু add করতে হবে, এখানে একটা star mark দিয়ে রাখবেন তো। Star mark দিয়ে রাখবেন, আমি একটু add করতে হবে। এই যে discuss করতে হবে।
Oh,
Yes, 29.
29.
Miller, this is my application.
Respondents? Mr. Bhagwan.
Miller, this is my affidavit of service. Miller, my predecessor was the recorded owner in respect arising out of a proceeding initiated under the Malad, the West Bengal State Acquisition 1953. Now their name was finally published under section 44(2)(a). Now, my lord, subsequently after the death, the legal heirs of the deceased, my lord, sold out the portion of their property to the petitioners. Now, on the basis of this purchase, my lord, my name was duly been recorded in the relevant record of right, as well as the corporation assessment roll. Also, can you turn to page 106. Before that, my lord, 105.
Yes.
My lord, Kishan M. Agarwal is the petitioner number 1 before your lordship. Next, Kishan M. Agarwal, he is the petitioner number 2 before your lordship. And Khogesh M. Agarwal, he is the my lord, the petitioner number 3 before your lordship. Then lordship kindly turn to the next page at 109.
Yes.
Now this premises number is converted into premises number, my lord, 854 Anandapur.
Yes.
And before that, my lord, lordship kindly mark at 107 page that column 5 is Shotto. I have been described as a riot.
Yes.
And your lordship knows, my lord, in terms of section 4 of the West Bengal Land Reforms Act, a riot is enjoying heritable and transferable right. Then, my lord, lordship kindly turn to page 114. This is issued by the additional district magistrate LR and LR department, South 24 Parganas. This is a so-called notice, but it starts from 113. A common notice was issued. My name is the name of the petitioners is appearing 5, 6, and 7.
Yes.
You are directed, next page, 114. You are directed to show cause within 14 days from the receipt of this notice for unauthorizedly. Can you mark this portion? Unauthorizedly occupying RS plot number such and such in Mauja Tiljala, which legally belongs to RR department, failing which appropriate action will be taken as per the law. Then, my lord, lordship kindly see, my lord, immediately, my lord, are asked to the office of the respondent. I have pleaded in my petition that what information I gathered. And on the basis of this information, my lord, I collected those documents, my lord, and kindly turn to page 115.
Yes.
My lord, this is the cancellation notification pertinent to a proceeding initiated under the West Bengal Land Development and Planning Act 1948. Next page, your lordship will find 116.
that under this notice, this is notice under section 6, a portion of my land was acquired. This is, my lord, kindly mark the date, my lord, it is 16th November 1956. Your lordship has got it. Then, my lord, this is, next page is 117. This is certificate of possession.
Yes.
Now, certificate of possession of land made over to the particulars on whose behalf it has, parties on whose behalf it has been acquired. No mentioning, nothing. It's a mere paper transaction. And I will come to your lordship later on. Then, my lordship, kindly turn to the next page. Now, this is the alleged award. It's an inquiry under section 11 of under Act 1 of 1894. Then, lordship, kindly turn to page 119.
Yes.
Kindly mark it, my lord, that there is no reason has been given that what prompted them to deposit in a revenue deposit. No determination under section 30, no determination under section 31.
So your post-vesting purchases.
But I am coming to that. I am coming to that. But kindly turn to my respectful submission before your lordship will be this. In the eye of law, there is no award. Under section 8, subsection 2 of section 8 of the Act of 1948, that is West Bengal Land Development and Planning Act. Why I am saying this? This is the West Bengal Land Development and Planning Act.
Yes.
Kindly have a look at the section 8. 1.
Yes.
After making a declaration under section 6, the state government may acquire the land and thereupon the provisions of the Land Act 1894. Herein referred to the section referred to as the said act shall do as per applicable, provided that if any case the state government so directs, the collector may at any time after a declaration is made under section 6 take possession in accordance with the rules of any bill, bar, tank or other facility area or any waste available land in respect of which a declaration is made. Thereupon, such land shall vest absolutely in the free from all encumbrances. Before that, my lord, kindly see, government may acquire the land and thereupon the provisions of the Land Acquisition Act 1894 shall so far as may be. Now next turn to, my lord, the B, which is very vital. In determining the amount of compensation to be awarded for land acquired in pursuance of this act, the market value referred to in clause 1st of subsection 1 of section 23 of the said act shall be deemed to be the market value of the land on the date of publication of the notification under subsection 1 of section 4 for the notified area in which the land is included, subject to the following condition. Now, what is the condition, my lord? If such market value in relation to land acquired for the public purpose specified in clause 1 of clause D of section 2 exceeds by any amount the market value of the land on the 31st day of December 1946, on the assumption that the land had been in that date in the state in which in fact was on the date of publication of the said notification, the amount of such excess shall not be taken into consideration. Meaning thereby, my lord, my way of understanding is this. Whenever award has been declared taking into consideration subsection B of section 8. Because this is the mandate. This is the mandate. Now, my lord, this mandate has been declared ultra vires. And state government has not come up with an amended provision subsequent to this. Now, what has been said, my lord, that principles of section 11 will apply. What is section 11? Let's can have a look at. Never said that section 11 will apply. Only section 11. Because award is to be declared under subsection 2. Not under section 11. Only the principle set out in the section 11 will govern. Kindly have a look at them, my lord, the section 11 ones. I am handing up my book, my lord. I am handing my book.
Yes.
Yes, my lord, may I continue tomorrow? Because 11:50, I will take some time. I will continue.
Not tomorrow. In that case, you have to come after vacation, Mr.
My lord, I need some protection from your lordship, my lord. I need some protection. Because they have not taken possession. I am in possession here. I have shown to your lordship unauthorizedly. Because I have also taken the plea of adverse possession in this case. I have taken the plea. My lord, this should be, I admit, my lord, this should be decided by way of an affidavit. I have also taken, I will also taking a point, my lord, the principles of disuse. They have not given effect to the anything, to the notification. I am praying a limited protection from your possibly my learned will not object because I am unauthorizedly enjoying the possession, my lord. So until this is being decided by this court that whether I am unauthorized or authorizedly, my lord, I need some protection for your lord at least for 15-20 days and let it appear, my lord, I don't mind. Possibly, Mr. Bandopadhyay.
The notice has been issued on the 24th.
Immediately I come. Immediately I come.
In the meantime, no step has yet been taken, my lord.
No.
Only. Within 15 days.
Next item is I am going to state.
Same matter. Can there be an order of status quo?
Only as regard possession.
As on this.
As
date?
the
With regard to possession, that's
yes,
all.
as regard a limited period, my lord, I am praying for. On one more thing, my lord,
Are affidavits required or you'll come back with a report?
my lord,
Because my lord, act of plan.
Affidavit of service.
my lord, I also like to use a supplementary affidavit. Kindly grant me the time to spare.
Yes, yes.
But only the supplementary, I will not issue any.
On prayer of the petitioners, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, heard learned counsels for the parties, comma, upon consideration of the submission made on behalf of the parties, this court is of the view that the matter needs to be heard on affidavits. Paragraph, affidavit in opposition be filed within 2 weeks after vacation. Within 2 weeks after the summer vacation. Stop affidavit in reply, comma, if any, comma, be filed within a week thereafter. Paragraph, let the matter go out of list for the time being. Stop, liberty to mention. Paragraph, since the petitioners claim to be in possession of the plots in question till date, comma, let there be an order of status quo in respect of, yes, 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 in respect of possession of the plots in question upon both the parties as on this date till 30th June.
Deeply obliged to you,
June
Lordship.
2023.
Both the matters, my lord. Next matter is also the same.
Same
matter.
order?
Same order.
Corrector, same order.
30,
30, same order.
My lord, may I take back my movement?
Yes, ওনার বইটা ফেরত দিন।
দিয়ে দিয়েছি।
Oh. Deeply obliged to you.
এটা ইনকম Group 7 contempt application, item 157.
Madam, I'm for the petitioner, madam. Well, I instructed to appear on behalf of the alleged contempt. 7, 8 and 9.
It has to be served upon the contempt application.
He's appearing here. He says he's appearing for the
It's
contempt.
appearing,
Yes.
the contemptor should be served.
Additionally, I shall serve. আমি তাহলে দুটোতে দিয়ে দিচ্ছি।
Service direction. No, at the moment, I think you cannot appear. Let it be served. It is appearing for the first time today. It is appearing for
Oh,
the first time.
first time. First time, madam.
So he cannot appear without instructions like this.
Only his instruction for that reason he says.
Contempt application.
I should serve, madam.
Service direction.
সার্ভিস করবে তাহলে তুমি নিও না
14 June.
14 জন আমি দিতে পারো তুমি নিও না এগিয়ে যেতে পারি 3 জন
157. 158.
but same
Same?
same
Same date, 14 June.
$159.
মানে same madam.
Same order.
$160.
Yes, my lord. I'm appealing for the petitioners, my lord. My lord, this writ petitions was filed, my lord, against the,
Who is appearing for the respondents?
because on the last occasions,
Have you served the respondents?
Kumar Chakraborty and Mr. Surajit Kumar Ghosh.
because of,
There is
on the
there was a
last-
direction for service. Have you served?
yes, my lord, that I had served, my lords, and the matter restored, my lord. And in that particular notice, we intimated that the matter would appear on this today, 15th. এটা তো দেয়া হয়েছিল নোটিশ
That was restoration. Restoration
রেস্টোরেশন অ্যাফিডেভিট অফ সার্ভিসটা দাও ব্যবহার করো my lord, the filing of the writ petitions, my lord, that the scope of filing has become infractuous, my lords, only to that extent certain orders has to be recorded, my lord. But it is a case, my lords, that the rail by issuing a, my lord, a purported order of suspensions, thereby suspending the allocations of priority C recs, my lord, for transporting iron ore, my lord, for the purpose of manufacturing sponge iron. Because now, my lord, that the requirement of priority Cs is no longer is very relevant, my lord, because the freight, my lord, has become equal, my lord, at the same time, my lord, as the 80% productions has been converted into, my lord, palletizations, my lord. So therefore, this iron ore's requirement by way of transport, my lord, is now, it has become less. So therefore, that interim order is no longer required, my lord. And, my lord, that filing of writ petition is also, my lord, not very much relevant. But in the order, my lord, I am filing, my lord, one supplementary affidavit, my lord, because in terms of the order of this honorable court, my lord, that the opportunity of hearing.
Please show me service upon the respondents because
Oh,
otherwise.
service
it will be
upon the-
difficult.
During the restoration, it was served.
My lord, during the restoration, it was
After
served, my lord.
restoration,
Now,
there was a
after the
direction for
restoration,
service.
no, my lord, that was not served.
After restoration, there was a direction for service
Oh, after restoration?
by an order passed on 11th April.
Oh, my lord, my learned
Will
to
you
be at
please
best.
serve and come back?
Yes, my lord, I will serve and I will come back.
Supplementary affidavit submitted on behalf of the petitioners is taken on record. Since
And I will also serve a copy of the supplementary affidavit.
the respondents is not complete, let the matter stand over till 12th June.
Yes, my lord.
I'll serve.
I am grateful to your lordship.
Supplemented or served?
Yes.
$161.
Yes.
Well, it's my affidavit. And I have stopped my non-material matter.
Let Mr. Shamanta make his submission first.
Well, I have submitted my affidavit by taking exception to the report. Well, I have challenged the legality and validity of the government order, my lord, communicating by the chairman of the RTA Purva Bardhaman. Well, if your lordship kindly come to page 18.
Yes.
Well, I am drawing your lordship attention. A. Madam, for considering the BS norms of vehicle to be placed under new permit, the clarification received from the Additional Secretary Transport Department by number such and such dated has been considered, wherein it was mentioned that hence, as regards to BS compatibility of vehicle for issuance of stage carriage permit, guidelines as enumerated in clause C of paragraph 2 under item 1, item A of the said order number 1643 dated 20th April 2013 shall be adhered to. Now, according to the stated clause of order number 1643 WT dated 28th of April, it is mentioned that, quoting, in case of stage carriage permit, in case of interstate permit not relevant matter, in case of interregional permit not relevant, the third matter, the route is exclusive within Kolkata is not relevant. Number 4, if the route is exclusively outside Kolkata, the new vehicle to be placed in permit should be minimum BS3 norm compliant. I joint issue there, my lord. If you say new permit, new vehicle, kindly see, new vehicle, that cannot be converted to BS3 norms. If you could have said vehicle, I would not have joined any issue. When you have stated in the government order new vehicle, new means new registration. I have challenged that portion of the government order. This is contradictory.
The entire notification is with regard to new vehicle.
Yes. Well, I have taken on that point, self-contradictory. Contradiction is there.
What does the report say?
Well, here also kindly see the report. Kindly see the report. I have also taken point that the report ought to have been filed by the Transport Department, not by the Secretary. Because Secretary, District Magistrate being the chairman, had referred the government order. Therefore, that government order is an challenge. Therefore, it is for the Transport Department to come before Lordship to file a report, my lord. Secretary has no business. Secretary RTA is not the author of the, or the DM RTA Bardhaman is not the author of the government order. Author of the government order is Transport Department. I have taken that point also. Kindly see the government order report. Who has kindly see? I am the Secretary Regional Transport Purva Bardhaman, being implemented as the respondent number 3 hearing. I am well acquainted, where I am well conversant to the facts and circumstances of the present case, having been dealt with the records of the present case in official capacity. I being the principal officer of the respondent number 2. How can he say so, my lord? Principal officer. I fail to understand how can he say so. Principal officer is the district magistrate, the chairman. He is the principal officer.
Regional Transfer Authority Purva Bardhaman. He cannot allege. He is the principal officer. Not correct statement.
You are holder of a contract carriage permit.
Maybe, my lord, but I am affected. Still then, my lord.
This is a stage carriage.
This is not
permit.
under challenge. I have come to your lordship because this policy itself, that will be made applicable to all kinds of permit.
How are you affected by this policy?
Policy, my lord, when the policy, government policy is there, my lord, contradictory policy, my lord, it will give effect to.
How are your rights infringed?
My lord, I know your lordship knows, but our special bench judgment. My lord, if he are affected,
How are you affected? That is my
my lord,
question.
because the new
Because
vehicle,
yours is a contract carriage permit.
then they can do everything, my lord, by that process. New vehicle, they will be saying new vehicle, they will be placing, my lord, BS3 vehicle.
In case of a stage carriage permit.
Stage carriage permit and contract carriage permit, my lord, contract carriage is also stage carriage, have been converted to stage carriage. Those permits,
That has not been done here in this case.
hey, my lord, I am not saying so.
You have to
I am
confirm
not
yourself to
contract
this
carriage,
case.
nature of vehicle is there. Nature of my lord, private operation, the stage carriage operation, contract operation. Contract to contract, my lord, point to point business, that is not being followed. Contract carriage permit issued by the authority is being allowed to be operated stage carriage. Even the fare table is also given to them, my lord.
So
Time
you're
table is also
operating it as a stage carriage permit.
stage carriage permit, fare table and timetable is issued. In the case of contract carriage permit, fare table is also issued.
Yes.
But only fare table cannot be issued. They can only say rate of fare. But fare table, point to point fare table, they cannot use. Then that will mean the stage carriage. That came, my land page appear, my lord. This issue, my lord, the particular issue came up before this division bench, when my land friend and myself appeared in 1987. My lord, Mr. M.N. Rai, as his lordship then was, my lord took advantage of riding the minibus service and took the ticket and came back to this court. On the next day, he produced the ticket. Well, you are issuing stage carriage ticket and you are alleging contract carriage permit. That you can do. You have to convert. And that then after my lord, the conversion order was passed by this court.
In your case, has it been converted?
No. I'm not saying, but I will challenge.
How is it relevant?
And if your lordship says that I have no authority, then your lordship deal at that point, my lord.
How is it relevant in this case?
I have said so, my lord. How is it relevant, my lord, in my petition? My lord, kindly come to paragraph 3. Paragraph 3 and 4.
Yes.
The petitioner says that the petition is highly affected and prejudiced by the impugned resolution of the respondent 2, dated 30th April 2022, regarding the decision taken by the authority in item number 13 for the grant of stage carriage permit in favor of respondent 4 in the route between Samanti to Memari via Sasansar. Respondent 2 had referred to the order issued by the respondent 1 being Ahmed Hassan sir. It was also alleged that the additional secretary transport department having directed to the effect, hence as regards BS compatibility, that is there, my lord, in the case of stage carriage, interstate route. Paragraph 4, my lord. The petitioner states that the petitioner is an existing operator or contract carriage permit, operating his vehicle in the route between Memari to Samanti, in the same route, Paharati, Ahmadpur, and the petitioner has no custom to challenge the impugned resolution of the resolution dated 3rd April 2022, alleging compliance of the order of the transport respondent 1 being number such and such, as the government order is arbitrary, illegal, and contradictory, cannot be acted upon as such. The petitioner entitled to challenge the said decision of the respondent 2 dated 30th April 2022 in terms of the law declared by the special bench of this honorable court reporting such and such, whereby and wherein it has been declared inter alia to the effect that the existing operator has right to challenge the illegal grant of permit. In the case and context thereof, this interpretation preferred by the petitioner is maintainable in the app law, and the same deserves to consider and adjudicated by on its own merit. That is
Where
my
is the
point.
challenge to illegal grant of permit?
Yes, this is legal grant. Because the government order is illegal. Government order is illegal.
Not
The
convinced.
RTA Bardhaman is taking advantage of the illegal order and issued and the taken decision for grant of permit. I have taken advantage of that, my lord.
How is your right infringed?
Madam, that is illegal
Do
grant,
not
my lord.
file.
I can, then we will also carry
If you are challenging an illegal
the
order, it
special
should be
bench
a
charge-
public interest litigation. as a
special bench
member of the
judgment special bench charge is to brought to is to be referred to your lordship, my lord.
public. Please show me the judgment.
My lord.
Please show me the judgment.
Madam, I have not brought to that judgment because I thought it your lordship.
Because according to you, special bench judgment says.
Yes,
the
illegal
operator-
grant.
Operator has the right to challenge an illegal
That is
grant
declared.
of permit.
That, yes, that has been declared, man. That is
Yes,
different.
provided your right is infringed. Not before that. Otherwise, it's a public interest litigation.
My lord, the
You're
permit,
challenging as a member of the public, not for your individual rights.
no, my lord, I have been an operator of the route, I have challenged on the same route.
You are a contract carriage operator.
Maybe, my lord.
This is a
Still then,
stage
my lord,
carriage-
I can come. According to my humble submission, when the law declared by the office court, by this court.
Please show me the
But
provisions.
yes, I shall do this. On the next day, as well.
Mr. Debra, what is your submission?
I think, I fail to understand is clear. He is a contract carriage operator. First paragraph is saying that the
I have not-
operator of permanent contract carriage.
I have not hide it.
He is challenging the stage carriage. I fail to understand. Is calling for your lordship also, my lord, as special bench, reference the special bench in case of stage carriages. Not any contract carriages. Kovat Pan, I have tried, my report lordship can see, Kovat Pan judgment is there.
You've referred to Rosh.
Not to bother, yes. Fine, fine.
Let Mr. Shamanta come back with the provision.
Yes, sir. And the report, the affidavit, he says the principal officer, but the report cannot be filed by him. Report should come from the transport department.
Why?
You
First you satisfy your
maybe,
legality of
but the affidavit is when it is filed before the court.
Go before the field. That is.
No. You said that you are the principal officer of the restaurant too.
Please come back.
Existing operator, you have no right.
Exception used by the petitioner. Exception used by the petitioner to the report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, all learned counsel for the petitioner. Paragraph, the petitioner pays for accommodation. Let the matter appear until the same hearing. On 14th June. 14th June.
For further consideration.
Yes.
For further.
Yes.
162.
The cause order. Now, my lord, in this matter, your lordship,
Mr. Debra is appearing in this one.
yes.
Sarangi.
Sarangi.
No. Lordship already passed the order.
Yes.
And also hearing also placed. That's why.
It's good to know. But on 15th March, your lordship was pleased to pass the order, directing the authority to decide the issue within 2 months and to submit a report. Now, my lord, the authority initially did not,
So why is this matter appearing today?
because of your lordship's direction, 15th March.
No, this matter, I think, no order was passed.
15th March.
This matter was adjourned, no order was passed, but
No. This is the order.
subsequently, all order has been passed.
Oh, a report in the form of affidavit was called for.
No. Your lordship can see the order dated.
Matter earlier. On
Order dated 15th March 2023.
Yes.
15th March 2023, your lordship kindly see.
A report was
Your,
called for from the respondents.
your lordship kindly come to internal page 4.
Yes.
In view of the same, the Secretary, Transport Department, Government of West Bengal, being the first respondent herein, is directed to reconsider the application already filed by the petitioner and the subsequent application to be filed by the petitioner as directed by this court within 4 weeks from the date of communication of this order, receipt of this application from the petitioner, whichever is later, upon affording reasonable opportunity of hearing to all interested persons, including the petitioner, he or his authorized representative in accordance with law. The decision taken by the authority shall be communicated to the petitioner within a week thereafter.
within a day. It is expected the matter will be revisited by the first respondent without being influenced by any observation made by the earlier order in the light of the observation made in the earlier writ petition by the coordinate bench, as well as in this order. Upon consideration of the matter, a report in the form of affidavit to be submitted by the respondent on 10th May 2023, when the matter shall appear in the next. Now, your lordship kindly see.
Well, order, my instruction order has been complied with.
No order has been complied with. Now, my lord, dear lordship kindly see, they have, yes, they have asked me to appear on 12th April 2023. And they sent the notice, although it is printed 5/4, but I have received the notice on 11/4. When I was outside Calcutta, outside my place of residence, I am not in Calcutta, Midnapur, on account of medical ground. I informed them over telephone because they scheduled to fix them on 12th. They issued the notice on 11th. How can I appear? I cannot instruct also my lawyer also to appear on my behalf along with all the
The
papers.
matter has been taken up in your absence?
Matter has not been taken. I have sent them this notice to fix another date for hearing of the matter.
My lord, in that case, the lordship kindly fix 1 week after vacation. In the meantime, my lord, yeah, order has been complied.
You were supposed to come back with a report in the form of an affidavit today.
my
So please do that on the next occasion. And please take, instruct your client to comply with all.
Copy the petition.
Petition? Petition copy তোমাকে দেনি?
দেবে আরে নেয়ার কোথায়
We submitted on behalf of the
আসে না আমাদের
petitioner
problem.
that
কিছু সম্ভব
ও রিপোর্ট নয়।
in
আরেকটা
compliance with
রিপোর্ট
the
ফাইল
order
করতে হবে এই
passed
অর্ডার
on
অনুযায়ী।
15 March
ফাইল
2023,
করতে।
notice
সেটাই
of hearing
হ্যাঁ
একটা কপি দেবে আমাকে
দিয়ে দেবো।
served upon the
আমার প্রবলেম
petitioner
হয়ে যাচ্ছে
on 11th April 2023, fixing the date of hearing on 12th April 2023. Stop. The petitioner was unable to appear before the authority on the said date. And
অরিজিনাল কপি জিজ্ঞেস করো।
May I submit one thing, my lord? Lordship kindly-
requested fixation of another date. Yes,
Lordship kindly direct the STA to serve a notice upon the learned advocate. Otherwise, that will serve the purpose.
yes,
Yes, my lord, but at least 7 days notice to be given.
yes.
When 5th notice has been printed, served on 11th.
But 2 weeks after vacation, lordship kindly.
But that is not to be done. A person cannot appear in this manner.
আমাদের নোটিশ দিচ্ছে তো এবার তোমরা দেখো।
আরে আমাদেরই নোটিশ দিয়েছিল
Paragraph in view of the above,
হোয়াটসঅ্যাপে আমার জুনিয়রকে নোটিশ পাঠিয়েছে।
ঠিক আছে আমায় দিকে আমি পাঠাই
respondents are directed
আমি
to
বললাম আমায় দিয়ে দিতে হয়
comply with the order passed on 15th March 2023 upon service of prior notice upon the petitioner at least 7 days prior to the date of hearing. Paragraph or report in the form of affidavit be submitted by the respondents on the adjourned date. Paragraph, let the matter appear on the same heading on 16th June.
কপি
দিয়ে দেবো জেরক্স করে আজকে জেরক্স করে
তাহলে পক্ষে সুবিধা হবে তাহলে
তুমি যখন বলেছো তখন দিয়ে দেবো আর দুবার করে বলার দরকার নোটিশটা এটা রাখো
163,
My lord, 163, Mr. Soumitra Bandyopadhyay is appearing for the state respondent. My lord, he's engaged before court number 32. My lord, I'm praying for not today.
Lordship, no, your lordship, I am for the respondent authorities, respondent number 3, your lordship.
My lord, on behalf of Mr. Satvik Bhattacharya, who is appealing for the petitioner, I pray for not today, ma'am.
Come back after vacation.
My lord.
After vacation.
On prayer of the petitioner and the state respondents, the matter is adjourned. Let the matter appear under the same heading on 20th June.
I'm grateful.
Thank you.
I'm a petitioner.
164.
My lord, I am the petitioner in item number 164.
Private respondent, lordship.
Two matters
are- Two
My lord,
matters
I
are-
am the petitioner. I may be afforded opportunity to present my case first. 165 is my learned brother's case. Madam, Madam, may kindly hand over this.
I appear in 165.
165, your lordship had given direction to the state to take instructions because the principal secretary transport has issued two directives saying that please comply and allow registration of Mahindra and Mahindra vehicles. But there are some of the RTOs are not complying. So it's really an open and shut case. The state has to say why, despite the principal secretary's memorandum, two memorandums being issued to all RTOs, their RTOs are not following it. So may 165 be first taken up because your lordship had really called upon.
Also appearing in the other matter.
Yes, for the state, I believe. Okay.
My lord, this is my rate application. My lord, this rate app.
But my
lord,
learned friend is there for the
my
state.
lord, we have informed and
No, I understand.
Mr. Shukla Singh Bhol is appearing in the first one. Then you're in the second matter.
Yes, 165.
What about the first matter?
my lord, in the first matter, with regard to first matter, I have some humble submission, my lord. My lord, in this first matter, my lord, I have prayed for implementation of the memo issued in favor of Mahindra and Mahindra Limited, item number 165. My lord, without change of any terms and condition as mentioned in the learned Alipur court's order. My lord, since he was the party in the learned Alipur court proceeding, and my lord, the order of honorable division bench is squarely applicable upon them as mentioned in page number 12, para H.
My lord,
Without change of any terms and conditions.
My lord, despite even if the state is not here today, my lord, as a private respondent, I am in item number 164. I am taking a point of maintainability. Kindly
My
come.
lord, his rate is not maintainable because 164
Please,
has
we are only talking about 164. Please, kindly takes the writ petition 164 and kindly come to page 16, the prayer portion. That is 3152 of 2023. Well, kindly come to prayer B. I am a private body. I am a private incorporated company. Kindly see what prayers have been sought for against me. Prayer B, a writ in the nature of mandamus directing the respondents to obtain the patentee license as per letter dated such and such, being memo number such and such, e-rickshaw, Mahindra and Mahindra, stroke 2022, in regard to Messrs. Mahindra and Mahindra Limited, issued in compliance of order dated such and such. Lord, in a writ petition, can a writ petitioner ask for a mandamus against a private respondent, basically a incorporated company, namely Mahindra and Mahindra, for a mandamus asking them to take a patentee license from him? Is it maintainable? Lord, kindly reserves my right, as kindly reserves the point of maintainability. Let me file an affidavit to this and we can come back after the vacation. Let the state also file an affidavit. I am saying the writ petition on the face of it is not maintainable.
My lord, this is my
My lord,
rate
question
application.
of patent, if I have to take patent license from him or not, is not for the writ court anyway. It is for the tribunals and, my lord, the boards which are established under the relevant acts, namely the Patents Act and the other intellectual property law acts. Writ petition is not maintainable. How can he ask?
My lord, may I take your lordship to page number 59, my lord?
Cancellation of registration granted in violation of the order of injunction.
My lord.
Can this be done in advance?
My lord, it was earlier done by his lordship, Honorable Justice Somensen lordship, in the similar matter. I will place that order also in page number 59, my lord. My rate application.
He intends to come back with an affidavit.
Yes, I want to.
My lord, then I will raise also a point of maintainability with regard to his writ petition.
Let it be called on. You do that. Don't threat the court. I will do that. I will do that.
My lord, this is
Let
the way
item number 165 be called on.
This is the way, my lord. I am placing my submissions. He is
Don't make all these submissions.
My lord, is this a way of, is this a
You
decorum?
please answer to the
My lord, may I take
question
your
matter
lordship
that
to
has been
page
raised
number
now.
59?
Yes.
Both in the first writ petition.
My lord,
Please serve and come back.
Yes.
Let the state appear.
My-
Mr. Thor was appearing.
No, ওরও বলতে হয় না। এটা ছাড় না, এটা বাজে আমারটা তো।
None appears for the state respondents in WPA 3152 or 5152?
3152, my lord.
3152 of 2023.
Oh,
Paragraph, let the matter, let these matters appear under the same heading on 21st June. Paragraph, the petitioner in WPA 3152 of 2023 is directed to serve notice upon the respondents, state respondents intimating the adjourned date.
question of maintainability may be cooked.
The question of maintainability in both the writ petitions is kept open.
My lord. একসাথে with করেই আছে আবার কল হবে
My 166.
165, my lord. No, my lord, 165 is my writ petition. No, my lord, no, my lord, kindly allows me. 165 is my writ petition.
Both the parties, the matters have been taken analogously.
No, my lord, kindly appreciates. 164 is his writ petition. No, my lord, that is his prayer. 164 is a separate matter. I am saying it is not even maintainable. 165 is my writ petition. Kindly takes it up for 1 second.
Both the matters have been.
My lord, they are completely different. My lord, this is a completely different matter. I don't know why my learned friend is saying that. Kindly takes 165.
The order was made in presence of both the parties, so please come back on that.
No, my lord, there is no combined order. These are all separate orders that are being passed.
Let's read
One,
this.
kindly see what 31.
change and change.
165.
No, but kindly see all the orders are
My lord,
separate.
after
Kindly see
consenting.
3152.
Yes, sir.
All orders are separate, my lord. It may be taken up as a bulk of matter, but all matters are different. This is my writ petition. I'm CV. My entire sales in the state is stopped. My lord, it may have been tagged along, but my question is that it has to be separate. No, my lord, no, my lord. It is there, his prayer. I have never said. But I cannot say. Yes, my lord, kindly see all different orders are being passed every day in the matters. There is no, my lord, even order of analogous hearing. Now, kindly see, takes my writ petition. I'll only show you 2 documents. Kindly come to first page 73.
You are the private respondent in the second matter?
My lord, I have objections
Yes.
because, my lord, so many facts have been suppressed.
Yes,
I will prefer
Certain-
affidavit in opposition.
Certainly, let him.
My lord, they have filed Hooghly notice,
Certainly.
miss case to get an favorable order.
First,
my lord.
allow,
But
kindly allow me to place the, kindly allow me to place 2 documents in the writ petition. Minus 5195. Yes, but
My lord,
kindly
point
hear-
of maintainability may be kept. open.
let him argue everything. Kindly hears me for 5 minutes, then your lordship will hear him. Kindly see page 75. Kindly takes page 75.
Yes.
Only 2 documents, page 75 first. Kindly see who is issuing this. Government of West Bengal Transport Directorate. Issued, signed by Director Transport Directorate. What is he saying? Approval of registration e-rickshaw manufactured by Mahindra and Mahindra Limited. As you know, the registration of e-rickshaw was upheld in conformity with the order of the Honorable Court of Additional District Judge Alipur, South 24 Parganas. Now, as per solemn order dated 3rd June 2022 of the learned Additional District Judge Alipur, South 24 Parganas, only the e-rickshaw models belonging to Mahindra and Mahindra Limited may be allowed to be registered by the registering authorities of this state. Then, therefore, all the registering authorities are hereby requested to take necessary actions in compliance with the efforts of solemn order in terms of notification number such and such, in terms of conditions as specified in the certificate as issued by certificate authority ICAT. Kindly see the order of the circular 14 July 2022. My lord has seen 14th of July 2022. This is none other than the Director Transport Directorate. Now kindly come to page 91. Only 2 documents, nothing else. No, 91. Now kindly see, this is of 9th September 2022. That is July, this is September. Same, the Director Transport Directorate is issuing a circular to all the Directors Transport Directorate sorry, or to all the regional transport officers, additional regional transport officers. With reference to the above, this is to inform you that a letter VDA number dated such and such, registration of e-rickshaw Mahindra and Mahindra stroke 2022 dated 14 July 2022 was sent to you for taking necessary action in compliance with the solemn order dated 3rd June 2022 of the learned additional district judge Alipur, allowing the registration of only e-rickshaw models made of Mahindra and Mahindra Limited. But it has been reported by Mahindra Limited that some RTOs are not complying with the said order of the learned additional district judge Alipur. Hence, all concerned are requested once again to comply with the said order. The officer of the state government, the concerned director of transport directorate, is issuing 2 circulars, same nature, July and September, asking all RTOs to register my vehicles. And my lord, this is passed. This directorate is passed on the basis of his concession dated 3rd June 2022, which your lordship will get at page 74.
You're asking for compliance of these two.
Just these two, the state authorities have issued, the RTOs are not complying. The private respondent has nothing to do. The private respondent has nothing to say regarding these, my lord, communications made by the transport directorate. And he has given his consent in the learned trial court. So, my lord, all that your lordship said was the state should file a report or tell your lordship whether these circulars have been issued by the Directorate Transport Department and why are they not complying. That's all. My lord can ask them. Yes, the state has to answer.
So far, lordship, that page 75 on 14 July 2022 is concerned. My lord, that time, what happened, so far I recollect that in view of an, my lord, agreement and or the consent that, my lord, reached between the person who filed the suit, Mr. Konik Sinha, and, my lord, this Mahindra in that Alipur court suit, my lord, the plaintiff therein, my lord, gave consent that very good, Mahindra vehicle can be registered. Otherwise, there was a, my lord, the order, my lord, restraining the registration of those type of e-rickshaw vehicles. Now, my lord, on the basis of this, my lord, this order was, my lord, I think this is not the order. This is just, my lord, that compliance of that order which was passed by consent of the parties therein. To facilitate that, this is not the order, because no order can be passed bypassing and or, my lord, in suppression or, my lord, divorcing the, my lord, the order of either Alipur court or of the High Court, Calcutta. Now, these, after this, my lord, yes, thereafter, my lord, the another memorandum or another circular for compliance of the same.
September.
Yes. Now, my lord, does it appear from these 2 letters that which RTA disputed or, my lord, the rejected or, my lord, they are not inclined to, my lord, do their duties with regard to compliance of that Alipur court's order? This is my letter. I am not denying this at that point of time. But I think that my learned friend's contention, the petitioner's contention is that this is not being complied with. Then, my lord, he has to come with, otherwise, how can I take an instruction? My lord, there are, please, তুমি তো বলেছো ভাই, বলতে দাও।
আমি উঠে দাঁড়িয়েছি, বলিনি।
উঠে দাঁড়ানোর পথে তো তারপর নেক্সট স্টেজ হচ্ছে লাফিয়ে পড়া। উঠে দাঁড়ানোর পরের স্টেজ। I know it for last 40 years. Now, my lord, my humble submission is this, that when there is an allegation that the order of the, my lord, the any authorities order, that subordinates are not complying with, there must be some particulars that these and these RTA on such and such date, when the, my lord, the representation and or it was placed before them for the purpose of registration, they are not inclined to do the same or they refuse to do the same. There must be, otherwise, my lord, how can I take an instruction? He says that he is, I am not denying this, that this is the letter at that point of time, no doubt about it, because you proceeded on that basis that yes, this is the order passed by the Alipur court, giving some concession to me. And on the basis of that letter of concession and or the order coupled with that, we pass this order. Now, if you say that this order was in favor of me, but the benefit percolated on the basis of this order, I'm not enjoying this because your subordinates are denying the same. You have to place the particulars. Where is the particulars? Otherwise, how can I take it? Malad, there are so many RTS, regional transport authorities in each and every district. Then, my lord, how can I take instruction from in which district you placed your matter and they denied the same? Give me some particulars.
My lord, if then my learned friend's case is that there is no denial.
I have no case at all. You have not made out your case. That is the whole case. You have to made out your case.
He needs particulars.
Yes. First of all, if he reads his brief, then he would have been able to understand. Kindly come to page 91. The second communication of the Director Transport Directorate, his own officer, records, but it has been reported by Mahindra and Mahindra Limited that some RTOs are not complying with the said order of the learned district judge. Hence, no, I am coming to that. So first of all, his own officer is recording, and nobody else than the Director Transport Directorate is recording that some are not complying. Number one. But he has taken cognizance of that. Then, hence, all concerned are requested once again to comply with the said order. My case, my lord, who wants to
fake allegation?
Please, I have not disturbed you.
And the fake response.
Mr. Government Counsel, I have not disturbed you. My question is, I am a yes, kindly, but why else would I come to court and expend my money? Kindly come to, first of all, pages 80, page 80. Onwards, your lordship, these are all communications in all our dealers. From page 80 onwards, dealers are complaining to us that the RTOs are not allowing. Kindly see first email. 4 or 5 RTOs. Yes. Yes, page 80. We would like to inform you that your approval of such and such to all the RTOs, our dealers are visiting local RTOs and requesting them to allow our e-rickshaw registration. However, maximum RTOs are not willing to start our e-rickshaw registration. So we would like to kindly guide below mentioned RTOs to start Mahindra and Mahindra, and 5 are categorized. Then, my lord, we have also given, I am not troubling your lordship with all the details of these emails, email after email from our dealers. Kindly, my lord, come to a chart which we have appended at page 92, my lord, which shows how our sales relevant is at page 93. My lord, kindly takes it horizontally. Kindly see how the registration of e-vehicles have gone down from January 2022 to January 2023. Most of the RTOs are 0. The last column, if your lordship sees, are all 0, 0, 0, 0, 0. My lord, this is the problem. Then, my lord, we have, my learned friend says, where will he take instruction? My lord, kindly come to page 185. My demand for justice to the Principal Secretary and Director Transport Directorate. He will take instructions on this. Page 185. My lord, a company who is doing business, I want to try and be a part of the green revolution. I am manufacturing something which has nothing to do with the private respondent. He goes himself to the trial court and says, yeah, very well, I don't have any objection in Mahindra and Mahindra vehicles being registered. The State Transport Directorate issues 2, my lord, circulars, one after the other, to the RTOs. RTOs are not complying. State is saying, I do not know what instructions I will take. But if that is the case, my lord, kindly directs the RTOs to comply with these 2 circulars. That will be the end of the matter. No, my lord, instructions is required. If the state has said, has not denied that the Director Transport Department has issued these circulars, all your lordship has to do is to direct that all the RTOs should comply with the circulars. That's all. But the business is coming to a standstill.
I have no objection, my lord. Yes.
Yes.
Blanket order on all RTOs.
That's right, to comply.
Circulars.
That's right.
Yes, unless there is any other subsequent circulars from this.
Very well. Kindly also mentions that. No
My
problem.
lord, I have objections with regard to this, my lord. My lord, may I take your lordship to page number 73?
My objection is limited, my lord. Page number 73, para 3. My lord, at the outset, the plaintiff who appears in person to conduct the case submitted that he has no claim against Mahindra and Mahindra Limited and he has no objection if the injunction order passed by this court is varied. He further submitted that he has no grievance or objection if Mahindra and Mahindra Limited obtains license by following the norms. My lord, these terms, my lord, my learned friend wants to change it in the writ proceedings. If he's agreed by this condition, by this consent, my lord, my humble submission is that with regard, by keeping this order in light, my lord, the memo has been issued to all the RTOs. And why RTOs are not been able to register? Because they have not complied with this consent. They need to comply. If they are agreed by this order, they need to challenge this before the appropriate forum. Sir, I have not disturbed you. Let me finish my argument. My lord.
Because of this contempt petition.
My lord, I have no objection. If the without change of any terms and conditions, directions may be given. I have no objection.
The memorandum
My lord, may I take you? My lord, again, my learned friend is interrupting. I have not interrupted. My lord, I have not interrupted. My lord, see. My lord, personal nature comments.
The memorandum.
My lord, may I take your lordship to page
Your
number?
argument is taken care
My
of
lord,
in the memorandum. The memorandum
My lord,
clearly
my lord,
mentions
may kindly afford
the order
opportunity
dated 3rd
to
June.
place my arguments, my lord.
Please, let us cut the matter short. 3rd June order 3rd June 2022 order is the primary order.
Yes.
My lord.
It's required to be complied.
Yes.
My lord.
You have no objection if this order is complied with.
Yes.
My lord.
Yes.
My lord.
So what is the?
My lord, with regard to one letter has been suppressed by Mahindra and Mahindra Limited, that is of dated 29/3/2022. My lord, by which? My lord, they have suppressed. That's what I want to bring it on affidavit in opposition.
What is the letter?
My lord, in this letter, Transport Department rejected the Mahindra and Mahindra application for registration stating, I am also directed to inform you that although Honorable High Court passed an order dated 18/2/2022, my lord,
The March
my lord,
document
my lord,
of
this letter has been
2022.
suppressed.
The
My
order,
lord, without this letter,
the order of
my
the
lord,
learned
the court
trial
will not-
judge is 3rd
My
of
lord.
June. This is his problem. He goes everywhere and he misleads.
Show me the document.
This is a document of March
My lord, see
2022.
the
The order of
please, conduct of the
the
writ
order
petition.
of learned district
Why
judge
this
is 3rd
fact has been
June.
suppressed?
Not a question of suppression.
I will bring more things on
I'm
record.
not supposed to
It
cite
was
the
suppressed.
Maharashtra and the Odyssey for a writ petition. What has happened? in
My
the
lord,
past?
in the 3 June 2022 order passed by learned Alipur Court, the Alipur Court has ordered registration in compliance of 18/2/2022 order. And on the basis of 18/2/2022 order, additional secretary issued a letter to the Mahindra and Mahindra Limited that we are not empowered to differentiate between the technology used by you vis-a-vis subject matter of title suit.
Letter that you're citing.
My lord,
Please.
that letter was suppressed. Secondly, my lord,
Show
they
the
have,
letter. What you're giving
my
to the
lord,
honorable court.
the honorable division bench also.
May I tell one thing, lordship? On this matter,
My lord, let it be decided on affidavits, my lord.
Well,
My lord, this has to be,
this is
many
his
things have
ploy.
been suppressed, my
He
lord.
wants to arm twist a corporate
By
giant
emotional
like Mahindra and
background, by
Mahindra,
things that
and this only
trying
happens
to
in
get
West
the order.
Bengal.
29th March.
But it has to be brought on
After-
record, my lord.
after the
Because,
3rd
my
June
lord,
order
it
is there.
issued to them.
The writ petition asks for the implementation of 3rd June order.
Yes.
My lord, I have no objection, but page number 74. My lord, it is having, my lord, page number 74 of
Kindly passes that order.
my lord, page number 74, one para, my lord.
For the parties. Writ petitions. See. Compliance of the office memorandums issued on 14th July 2022 and 9th September 2022. Stop. It appears that the memorandums have been issued in compliance with an order passed by the learned additional district judge 13th court Halifax on 3rd June 2022. Title suit number 27 of 28. Stop.
75 and 91.
The private respondent hearing, comma, the plaintiff in the suit as the said order records that the plaintiff, who is the private respondent hearing, submitted before the learned trial court that has no claim against Mahindra and Mahindra Limited and no grievance or objection if Mahindra and Mahindra Limited obtains license by following the norms. Stop. Mr. Sen, you also have no objection to this. Compliance of your own notification. Yes.
So, and unless and that has been challenged. So there is no.
Paragraph, it is needless to mention that the state respondents do not and cannot have any objection to implementation of the memorandums
No, there is, it's not very.
by the Director Transport Department.
Dated.
The same is varied by any subsequent, by issuance of any subsequent memorandum. Paragraph, in view of the above, the petition is disposed of, directing the
RTOs, my lord.
I'm a regional director.
all the RTOs should be.
All our parties.
Well, all the respondents. All the RTOs, my lord. Respondent numbers, my lord. 2, my lord.
2 till then.
2 till the 2, my lord.
35.
2 to 35. 2 to 35, my lord.
Directing all the RTOs, comma, being respondent numbers
2 to 35.
35. To comply with the memorandum. Implement.
Comply and follow, it's the same thing. Comply and follow, there is no difference. There's a compliance only. Has to be his own officer's order.
/ implement.
Yes, well.
Comply with / implement.
Well, the two memorandums are dated 14 July. My lord kindly mentions the memorandum number dates. My lord, 14 July 2022 and 9 September.
Both are by the Director Transport.
Yes, my lord.
Director, Transport Directorate on 14 July 2022.
And 9 September 24.
September
2022.
2022 respectively.
In allowing registration of the
Provided no subsequent memorandum in variance of the same has been issued by the authority subsequent.
Is already mentioned in the memorandum. It's already there in the memorandum. Says so, 3rd June. Why is he saying all this? I do not know.
The memorandum says.
My lord, may I clarify this because issued
He only
the order.
yes, whatever mentioned means all. No, he wants clarification. Yes.
The memorandum is clear.
My lord, I will communicate this order.
Yes, next.
Sir, I'm so deeply obliged for giving us a patient hearing.
166.
Yes, Lordship, in the fact matter, I'm appearing on behalf of the petitioner. So the affidavit of service of the petition. On the. Pardon my lord.
Respondents?
I'm on behalf of the petitioner, but
yes, please appearing for the respondents.
Lordship, in the instant matter,
Just wait for a minute. This is request to appear on this one. Respondents are served. It's the transport authority. Please serve him a copy of the request. The transport directorate and several regional transport officers.
Evans or prayer.
Please give him a copy. Please place your case.
Yes. So, my lord, previously on the 2 occasions, that is. Yes. Yes, that is under writ petition application on 25042 of 2022, as well as under the writ petition application 23440 of 2022, where we were the advocate on record and we were the similarly circumstanced in those particular writ petitions, like the petitioner in the instant petition. So these are the
Yes, sir.
so lordship. If lordship comes to page number. Lordship kindly arrows me on. Yes, lordship kindly comes to page number 73 of the writ petition, where under the notification published by the government of West Bengal, its transport department on March 11, 2013, was stated that the manufacturer dealers purchasers of the vehicles have since been complaining about the delays in the registration process, and it has been legally opined that the state government has no direct role or obligation in the registration process or in the process of the prototype vehicle certification or in granting permission for registration of particular model of vehicle. But if, on the other hand, if my lord comes to the page number 767 of the instant petition.
67.
Yes, that is annexure P5. So it has been held that only to Mahindra and Mahindra, the e-rickshaw manufacturer registration will be just given. So upon this, based on these contradictory notifications, then the petitioner in the instant matter is just suffering irreparable loss and injuries, where if my lord comes to page number 18 of the instant petition, your lordship will have found that it has been written that the several buyers of your petitioners manufactured battery operated vehicles who are based out of the Bankura, Paschim Bardhaman, Kim Dinashpur, Hubli, Howrah, and so many districts had already been granted the registration.
Because the earlier notification was in 2013.
Yes, but
After that, the title suit came up.
Yes,
And there
lordship,
is a different order.
lordship, yes.
That notification is redundant now. The 2013 notification becomes redundant.
Yes, but the
Subsequent order of the court.
lordship, the later on, the registration had been granted, but due to the reasons best known to the West Bengal government transport directorate, those particular registrations were not renewed to my client or to the petitioner in the instant matter. So in the instant, that's what I'm saying, my lord, in the instant matter, the petitioner itself is similarly circumstanced to the matters which have, the orders of which have been just served down to the lordship, where the lordship privately said that if lordship comes to page number 3 of your lordship's order of writ petition 25042 of 2022 of either of those writ petition applications. The writ petition is disposed of directing the concerned registration authority to grant the registration of the e-vehicles manufactured by the petitioner, subject to the said vehicles being different and distinct from the category forming subject matter of the title suit pending before the learned additional district judge 13 court Alipur. So here it is already been it is already settled that the battery, which is manufactured by the petitioner in the instant matter, is different from the petitioner or the plaintiff in the title suit, which was pending at that time before the additional district judge 13 court on.
Mr. Sen, he is asking for the usual order.
Practically, but there is no averment. I have come across the area of there is any averment that Vehicle 6 for registration, then the matter that is different from what something matter, the Alipur court, because whatever the order already passed by your lordship, there is my lord mentioned there.
Yes, yes.
That
Where it is stated
that order is not with me right now.
that the battery manufactured by you is distinct and different from the battery which is the subject matter of the writ petition of the title suit.
Only mentioning Minder, yes, but there was Minder.
Minder was allowed.
Minder was allowed. Yes, but subsequently there are Minder several.
Yes, yes. So let me find out where it is stated.
Of government, government থাকবে যে এখানে সেটা সম্পূর্ণ different.
So, lordship, if comes to the page number, annexion number P3,
Yes.
which is just lordship, kindly asking.
Is there any such averment in your writ petition?
But an instance is there, lordship, if lordship comes to,
At least there should be that declaration or abatement.
lordship, we shall file, but lordship, if kindly comes to page number 17, lordship.
Last my lord, in all those matters, I have been treated as a party, and this is a non-joinder of necessary party. They are not made to party.
They do not have any role, lordship, they are only the intervener, they intervene everywhere. And make the misleading statements.
It's a way of making submission.
What is your role? How are you a necessary party?
They do not have any proper submission.
Whatever different category order my reference seeks to obtain, which I am not able to be, whatever I have heard, my lord, simplification of order, sending number of order has been passed, and in all those petitions I have been included as a party. My lord, this week is also canvas from the same show.
Prejudice if you are not included.
My lord,
Yes, that is.
What will be your prejudice?
my lord, if the order of learned court is modified, my lord,
No question.
my lord, then I
There
will
is
say.
no question. Alipur court order cannot be modified in this writ petition, you are aware.
And be not a single factor.
No.
Only thing that whatever the Alipur court order is, but if the vehicle prove that whether any person wants to register a
In
vehicle.
fact, all these orders are in terms of the Alipur court order,
My lord,
not in contravention.
Then
my lord,
So how are you prejudiced?
what is required, and what's for the section?
How are you prejudiced if you are not included as a party?
My lord,
You are not prejudiced. So
my lord, I have also filed.
if you come up with supplementary affidavit in this matter, please go through the order, please find out the requirements and file a supplementary affidavit accordingly. You have to specifically state that the battery manufactured by you is distinct and different from the battery involved in the title suit. Yours was the lead seal battery. Please find that out and come back to the supplementary affidavit. Yes?
My lord, I have only mentioned here.
No. This matter not necessary. Not necessary. Not necessary. You have not filed. It's not on record.
My lord, just now I have received my message from the clerk, my lord. My lord, let it be rejected, my lord, if your lordship so feels.
Affidavit of service, none appears for the respondents despite service. Mr. Sen, who is present in court and usually appears for the, yes, is requested to represent the state in this matter along with a junior of his choice. Regularized quorum, copies of the direction. Paragraph, learned counsel for the petitioner seeks to use a supplementary affidavit in this matter. Paragraph will then appear under the same heading on 20th June 20. Grateful.
One 67.
This is my application. This is my application, my lord. I purchased a vehicle, my lord.
State 166.
Lord, I purchased a vehicle from bank by participating in online bidding auction sale process, my lord, on the basis of an arbitral award passed in favor of the bank, my lord. Thereafter, my lord, the bank issued no objection certificate for lien endorsement, my lord. Thereafter, I filed an application before the RTO for transfer of name, my lord. It was not done, my lord. Thereafter, my lord, I filed a demand of justice on February 23rd, 2023. It was not done. Against that, I have come up before your lordship, my lord. Last occasion, the private respondent.
Lordship, I'm representing the bank. Lordship, on the last occasion, I have taken Lordship permission to take instruction from the bank. Lordship, there is a Lordship, the legal officer of the bank has been changed, Lordship. This is the reason I need
Asking for some more.
Lordship.
So in that case, will you come back with a report in the form of an affidavit?
Lordship,
So
I
that
will.
others are
Lordship.
Something, my lord, there is nothing to do with the suit, my lord. Because, my lord, there's a specific bar in the Arbitration Act itself under section 5, my lord. Therefore, my lord, it cannot be. My lord, I am armed with another judgment of this honorable court, my lord. I'm just placing, my lord.
There is an order of administrative injunction in the suit.
Yes. Even then, my lord,
So how do you
it
think
is
the
barred by
bank
res
can-
judicata, my lord. That is what I am going to argue, my lord.
Can
That is
that be
absolutely
please-
barred by res judicata, my lord.
What is what by resident?
My lord, one thing, my lord, the award has been
See, the
passed.
suit is barred by resident.
Yes, my lord.
So that has to be mentioned before the suit court.
No, I am not a party to the proceedings. It's a binding upon the parties, my lord.
You can
And
appeal.
in the meantime, my lord, what happened, my lord, the certificate, the registration certificate has expired, my lord. Therefore, there is no bar to register it in my favor, my lord. Let the suit be decided in accordance with
When
law, my
there is
lord.
an injunction on sale.
My lord, interim injunction is
bank
otherwise, my
violate
lord.
the order?
In that event, my lord, kindly one sees, my lord,
Let
section
the
5.
bank come back with instructions. I think you have your recourse in the other forum.
My lord, other forum, my lord, I am reports in this forum, my lord.
You have
It
to
has
be
been.
added as a party there. When a suit is pending,
Suit is absolutely barred, my lord.
can the writ court deal with it?
Yes, my lord.
Can the writ court decide that?
My
the suit
lord,
is
I
barred?
am armed with the decision of your lordship's court, my lord, where it has been specifically held, my lord, that if one award was made between the parties, has in fact in law has been deemed to have been dealt with the dispute in the award, second adjudication of the same in the suit would be barred by res judicata, my lord.
Decide this, sir. The suit.
My lord has decided, my lord. My lord, to say in this writ petition that it should be barred by res judicata, my lord.
Say that the writ court will say that the suit is barred by res judicata.
My lord, this is a forum shopping, my lord, is going on between the parties, my lord. They intentionally did
Why
not
don't you
afford.
Court and make your submissions.
My lord,
there.
I don't have that knowledge, my lord, prior to that, my lord.
You have the knowledge now.
Yes, my lord.
And limitation lasts from the date of knowledge. What is your difficulty? I think
Lord-
that will help you.
My lord, they are the defaulter. I have an award in my favor, my lord. Bona fide award in my favor, my lord. On the basis of the award, my lord, I have paid the amount. My lord. My business has been hampered, my lord.
Of the suit court.
My lord,
That has to be brought to the notice of the suit court.
that I don't know. I am not a party to the proceedings, my lord.
You can be added as a party. Why don't you apply?
Lord, suit is absolutely fine, my lord. How could they file a suit, my lord? When there is an award, my lord.
Question can be answered before the suit court, sir. Not before.
Your lordship, in similar circumstances, my lord.
We shall.
In similar circumstances.
This is a certified copy.
So give a copy of it.
My lord, we shall give.
It's a certified copy.
Eventually, we shall give it to them.
Why are you nodding, sir? Give a copy. This is the original certified copy. Yes, please.
My lord, I am relying on a decision of this honorable court, my lord, where it has been specific. Even they have not challenged the award, my lord. If the award remains, my lord, the injunction, nothing remains with the injunction. My lord, in that event, my award is also there, my lord, the award in
Can the injunction set aside in a section, sir? Can the writ court set aside an injunction passed by a suit court? In a title suit? Yes.
Injunctions cannot be operated on court, my lord.
Can the writ court set aside?
Itself is a court, my lord.
A simple question, can the writ court set aside the injunction?
Lord, I am not saying, my lord, to set aside the injunctions.
When the
my lord.
injunction is there upon the
But
parties.
kindly observe that injunctions cannot operate, my lord.
Not possible.
My lord, in that event, my lord, kindly call
Let
for
the
the.
bank, nothing will be answered here by the writ court. Let the bank come back with instructions and pass necessary order. That's all.
In that
Your
event,
remedy
my lord.
lies elsewhere, I'm sorry. Your remedy lies elsewhere. Learned counsel for the bank seeks to submit a report in the form of affidavit in this matter. Paragraph, you are appearing for the
Let private respondent 5 and 6.
learned counsel for the private respondent numbers 5 and 6 submits that the interim injunction granted by the civil court is in force till 5th July.
July 2020.
5th July 2023. Paragraph, let the matter appear on the same heading on 26th June.
But in the meantime, can I fly the vehicle, my lord? This is not my decision, my lord. Without certificate, I am like.
Without registration.
But registrations can be done already, sir. Certificate already expired. my lord.
How can it be?
Certificate expired, my lord.
Sir, this one, I is there.
Let the court decide, let the suit court decide. Next. I would suggest
26 June.
you can approach the suit court without wasting further time, that would help. You are waiting for an order in the writ court, which is difficult. Come back.
I shall try to satisfy your lordship in the next statement of all these points.
It's a wrong order by the suit court, the writ court cannot do. Next one.
168.
Yes, petitioner. None appears for the petitioners. Let the matter appear under the same heading in the month of June 2023.
নামটা আমাকে দাও দিয়ে দিই।
Please, June.
নামটা
169.
For the petitioner. But the petitioner has disappeared from the respondents. In this matter, but petitioner is become the owner of the auto rickshaw. Yes, my lord, this is a affidavit of service, my lord. I have for the private respondent also, my lord, so astride owner from whom I have got the ownership. But just only one prayer, my lord, that the petitioner's name has to be registered. For that purpose, petitioner has visited the concerned authority office, but they are not entertaining anything. So made an representation, which is annexed P4, my lord, at page 36, for considering the representation and for allowing the petitioner to enter his name. Yes, my lord. That is the demand of justice. I am sorry, my lord. Yes, my lord. Then I will make a representation, my lord. My lordship direct that petitioner is going to make another composite representation. Composite representation, that has to be considered within the stipulated period, my lord. You're asking for registration in your.
Yes, my lord, because I am plying the vehicle for a long time and paper publication also been made after transferring the vehicle in my name. And it has been subsequently became LPG, my lord. The registration number has to be changed also.
So therefore, let her file a complaint. Affidavit of service. None appears for the fifth respondent despite service. Petitioner claims to be the registered owner. Question.
Yes, please.
Was transferred in her state.
Vehicle number, my lord,
Fifth respondent.
WB 15B 8245.
Capital B. 8245. Subtotal. And submits that vehicle is registered in his name by the registering authority. Stop. The petitioner seeks to submit a comprehensive representation in this regard before the concerned authority and place for a direction upon the authority to consider the representation at the list. Paragraph it is submitted on of the state respondents.
My lord.
Secretary.
Yes, my lord.
And the first
Respondent number 4.
After complying with section 51(5) also. Here, my lord, original registered owner.
necessary formality.
All necessary formality.
Yes, my lord, after.
Time required, my lord, section 51(5).
My lord, let the authority concerned, let the petitioner inform about the formalities, my lord.
Paragraph in the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive
My
representation.
lord, kindly add one line, the authority concerned.
Within 7 days.
Yes, my lord. Yes, my lord.
7 days from date, stop. The fourth respondent is directed to consider and dispose of the representation within 2 months from the date of receipt thereof. Upon affording reasonable opportunity.
For which the authority concerned has to assist, let the petitioner know everything, my lord. For this purpose, petitioner is going from pillar to post, my lord. They are. Yes, my lord.
Serving a notice of.
Yes, my lord. At least petitioner should inform the formalities, my lord.
I'll dictate after you finish your submission, madam. Otherwise, it's difficult. To all the interested persons, including the petitioner, and upon the petitioner complying with all necessary formalities, comma, in 2 months in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of.
Grateful, my lord.
Grateful.
170.
Lord, I beg to appear for the petition.
170. 170 the bank is having.
My lord, the cooperative bank is a party, but perhaps, my lord, their stand is quite clear from the documents itself. My lord, yes.
May I tell, may I tell? My lord, this is a matter, well, I think this is a matter where player is there. Only, my lord, with regard to removal of blacklisting. Right to,
Okay. Yes.
any time চেয়েছিলাম বলে দাও
Yeah. No, no,
I'm a banker.
bank.
I am for the bank.
He's present.
You're for the bank?
Yes, he's present now.
There is a private respondent also.
Lord, there is a private respondent as well.
Sir,
My lord, served. So affidavit of service is on record, my lord. Affidavit of service is on record. Private respondent has been. My lord, here there are twofold players. First of all, my lord, the bank itself has said, asked for the authority to remove the, my lord,
No, hypothecation.
yes, my lord, the endorsement of hypothecation from the registration, and also
my lord, I have prayed for de-blacklisting the vehicle so that it can be transferred, because my lord, the loan has been liquidated admittedly. My lord, kindly turns to page 28 and 29. That should, my lord, clarify things. This is, my lord, the bank asking the RTO, and the next page as well. Page 36 is, my lord, the blacklisting that has been done. Although, my lord, I could not find any provision as such in the Motor Vehicles Act. 36 is the blacklisting, where it says that because an FIR has been made by, my lord, the person who was supposed to pay the loan, he did not pay. The vehicle was seized. I had to pay myself, and then it was again, my lord, released in my favor. And that person has gone, my lord, subsequently and made an FIR after this liquidation. And he has said a lot of things. The complaint is in page 40, including, my lord, some things about the vehicle. And that is the reason, sole reason why, without giving me any opportunity of hearing, my lord, it has been blacklisted. And page 40 is that complaint, based on which. And in that case itself, the police authority have said that they have not seized the vehicle because of this case or anything. That is also there, my lord, at page 47.
There was a deed of.
There was, my lord, that deed of agreement is at page 48. And thereafter, after he did not pay the bank, my lord, my vehicle was being seized, and my lord, was about to be auctioned. So, my lord, I had to cancel that agreement. That cancellation is also there at page 56.
Was it unilateral or bilateral?
The cancellation was unilateral because, my lord, I tell my lord kindly turns to that agreement that my lord is referring to at page 48. 48. That is the agreement that existed between me and the private respondent. He promised to pay the bank loan. Kindly see page 49, clause 7. That the first party will regularly pay the monthly installments to the financing bank. If the first party failed to pay 3 installments, then the second party will cancel the agreement. He, my lord, failed to pay a lot of, my lord, installments. Then, my lord, the vehicle was about to be, my lord, auctioned at the behest of the bank. I went and, my lord, paid the whole amount. And thereafter, the vehicle was released. That, my lord, finds at page 58. 58 is another document by the bank. They released it in my favor. Would my lord want me to point out the pages of the show cause notice and where it was about to be auctioned and all? My lord, that is also there, my lord. My lord.
The complaint is at page 41.
40. My lord.
Pertains to some land.
But yes, my lord, that is his complaint. That is comes completely extraneous from the vehicle and everything. And based on this complaint, my lord, The vehicle has been subsequently blacklisted, and as such, I can't transfer it or do anything about it, in fact. Land, and then he has mentioned the vehicle also. It's there. At page 48, my lord, kindly sees the police authority in that case before the lower court, my lord, the criminal court, they have said that the vehicle is not seized as per, my lord, in connection with that case. That my lord finds at page 48. Sorry, my lord, it's at page 47. 47, order dated 14/3/23. At the very bottom. Has not been seized by this case.
A fresh report was called for after that?
A fresh report was called for, that perhaps has not been filed as yet, but my lord, I presume that the state would also maintain this stand, because
Let us hear this.
My lord, after obtaining this copy of this petition, my lord, I have interacted with the ARTO HON'BLE, my lord, by which this blacklisting was made. But I just wanted to know from him that under which provision you have done so, because either under the Act or on the basis of any order passed by any court. He said, no, there is no such provision and there is no such order also. Then on my advice, blacklisting has been withdrawn. There is no blacklisting right now. He can, search there that
You have a document to that effect?
my lord, I have
Has to be.
today I have informed that the blacklisting against vehicle number such and such has been withdrawn by the ARTO HON'BLE. My lord, this has been, my lord, informed me, and I know, my lord, when it has been informed by the ARTO HON'BLE, then that, my lord, that is no more. Blacklisting means that no transaction can be made.
Yes.
With regard to that vehicle, tax payment, or my lord, insurance, or even transfer of the vehicle. Nothing can be done. So that, my lord, that has been withdrawn. So now it is free.
So your.
Now it is free. Now this is that already done. In today morning, yesterday I told them today morning it has been done. Other prayer that if, my lord, the bank issued section 35, that is, my lord, the declaration that the loan has been my lord, paid and there is no dues with regard to, then naturally, my lord, the hypothecation, that endorsement, that is to be deleted. There is also no doubt about it. After the, my lord, that declaration from the financier bank with respect to that there is no dues any further, then, my lord, on the basis of that, my lord, any endorsement on the registration certificate book that the vehicle is hypothecated, my lord, that endorsement should not be there, my lord, after that. That is deleted. The word should be there, that deleted. So far, my lord, the state is concerned, motor vehicles authority is concerned, my lord, there is no problem right now.
that endorsement, my lord, the bank has issued, my lord, at page 29.
Yes, on the basis of that, deletion হয়নি?
No.
Deletion, no, my lord, then I think yes, because of blacklist. Yeah. But now there is no blacklist. So that, my lord, the deletion of that endorsement.
Bank's part is over.
Yes.
It was only because of the blacklisting that.
Because of that, the FIR lost. But the motor vehicle authority has nothing to do with regard to that FIR. It's separate.
So I'll record your submission.
Page 28, 29, my lord, bank's intimation, my lord, regarding, my lord, the hypothecation, my lord, and form 35, my lord, according to the, my lord, the motor vehicle rules, my lord, the bank.
You also have no objection.
No.
And there is no blacklisting from today also.
Third learned counsel, both parties.
Well, may I deep losses?
No, should be for. Release of the vehicle in question. In a 14-wheeler truck.
Yes, my lord.
14-wheeler truck of Tata make. bearing registration number WB 29 capital B 4826 from the blacklist in the portal of the respondent authorities. Stop. The vehicle was hypothecated with the bank. And upon so and upon the petitioner liquidating the loan in full, comma, the agreement of hypothecation entered into by and between the petitioner and the bank was terminated by a letter issued on 30th December 2022. And the hypothecation charge was cancelled by a letter issued on the same date. The vehicle was blacklisted Where is the order of blacklisting?
At page 36, my lord. It's a screenshot taken from the portal, my lord.
By the RTO Tomluk from West Bengal due to a police case pending against the petitioner under section 420/406 of the Indian Penal Code. Stop. Paragraph, it is submitted on behalf of the petitioner that though an agreement was entered into by and between the petitioner and the private respondent for purchase of the vehicle in question, subject to fulfillment of certain terms and conditions by the private respondent, including payment of remaining installments to the bank for the same, comma, the private respondent failed to act in terms of the agreement for which the agreement was terminated by the petitioner in terms of clauses 7 and 13 of the agreement itself. Stop. The entire loan was liquidated by the petitioner. Stop. Paragraph, it is submitted on behalf of the state respondents that the respondents have withdrawn the order of blacklisting of the petitioner's 36 years of the petitioner's vehicle with effect from yesterday, he said, I think. With effect from আজকের date din. And the petitioner is entitled to keep with the vehicle in accordance with law. Paragraph In view of the above, nothing further remains to be adjudicated in the writ petition. So, yes, it's done. And the writ petition is accordingly disposed. Since no other problem. Since no other problem.
That means the petitioner, in the nature of matter was issued thereby directing the respondent authority to allow the transfer of ownership of vehicle of the petitioner to any other person.
The authority
they are-
can state with that.
One more.
And
No, accordingly, Minor, the player C of the reputation. Otherwise, this will create.
My lord,
Not necessary.
my lord, the hypothetical,
Because authority is-
hypothecation that is required to be removed from the, my lord,
I
the,
have paid the loan. This was practice. The player C only I am paying. In view of this, Millard, this read of the page 19, which is not in conflict with the admission made by the.
yes, yes.
Page 19, player C. Can you see?
In view of the, in view of the above, the writ petition is allowed in terms of player C.
And it's still.
If the House in order as cost, since you agree that the signature. This one.
Matters from monthly list. Item 972.
Your respondent.
In this case, my lord, I applied for grant of contractor's permit state corporation, page number 16. Page number 16.
Respondents.
Yes,
Mr. Seni Deputy, he is coming. If you start, I am coming. Well, kindly see the page number 16. This is the application, form number 2. For
What is
grant
the
of-
prayer?
The prayer, my lord, for this, set aside the resolution of the RP board meeting and to reconsider fresh in accordance with law. So much certain facts are required to settle the issue. So for this reason, my lord, I am placing first page number 16. This is the
16.
application
Yes.
for grant of contractor's permit, page number 16.
Yes.
The route, my lord, column number 4, to Parulia Bazar to Samudragarh station. The officer route, that's not route. That application was made with reducing fees. And also, my lord, that application was placed in the board meeting, page number 20.
20.
Page number 20. For serial number 3, Gaidappa, route Parulia Bazar to Samudragarh, my lord, decision was taken, notified route, along with the report of the MVI, need to be submitted for the next board meeting. That means matter was kept pending. So I moved the writ petition. Now can you see the page number 21. Transport Department of West Bengal, on 29 January 2010, government policy of creation of the SUVRA code. These are guideline page number 22. Guideline 1 to 6. But so far the guideline 1 is concerned, that is that restriction for grant of permit within the Kolkata Metropolitan, the judicial Kolkata, that has been withdrawn by another notification dated December 2018. So far the condition number 2 and 6 exist in the field. So what is the condition 2 and 6? No new official permits should be granted in roads and areas covering more than one district. No new permit
Zoning operation permit which we allow on national highways except crossings such any case and recognized points. Condition of 4, flying of new auto rickshaw on state highways shall be restricted up to a stretch of maximum 3 kilometers. 5, no new auto rickshaw permits would be issued covering more than 30% of the building roads in roads other than NH and state highways. 6, grant of three-wheel auto rickshaw permit within a particular district only may, however, be considered by the concerned RTA of the district after taking into consideration the road condition of road, traffic and safety and security. Such three-wheel auto rickshaw proceed within the ambit and scope of the Motor Vehicles Act and rules and this is the condition. So, my lord, this condition does not fall on this road because several offer letter was issued. Page number 26. Page number 26 onwards. Several offer letters was issued by the same authority, that is Purva Padman. Route value subject offer letter granting contractor permit. Parulia Bazar to Samudragar station. That offer letter was issued in the year 2019 on page number 26.
Yes.
Onwards. Now, my lord, I have challenged the resolution. Page number 29. Relevant portion, page number 30. A bunch of writ petition was moved challenging this resolution. And my lord, one single order was passed by another coordinate bench on 23rd September 2021 and relevant portion page number 32. Well, maybe the above bunch of writ petitions has arisen out of similar issues with regard to the resolutions of the Regional Transport Authority with regard to permit of either auto rickshaws or triggers of the magic vehicles. Next page, page number 33. Upon perusal of this writ petition, it appears that the resolution is not clear as the requirement sought from the petitioners. For example, in one case, permit has been asked to be surrendered, wherein the petitioner never had a permit at all. It appears that the standard format of resolution has been applied in all cases without specifically going in each case properly. I have heard learned counsel for the petitioner and for the state respondents. Mr. Omar Kumar Sen, learned additional government leader, appearing on behalf of the state, has clearly submitted that the resolution should have been better worded. In light of the same, I direct the Regional Transport Authority to take up each of these matters in the next board meeting and pass this direction for each of the now, pursuant to the direction of this Honorable Court, the RTA board has taken the decision, page number 34, serial number 6. Serial number 6. It's Route Parulia Bazar to Samudragar, and next there is a column decision of the RTA board. The applicant appeared before the hearing. It appears from the further inquiry report of immediate non-technical of Kalna, duly countersigned by ARTO Kalna, that more than 30% of the route overlaps bus route and also overlapping more than 3 kilometers of NHSH, which are violating the provisions of notification issued by the Transport Department. Hence, as per the state notification, an inquiry report, the application is rejected and the applicant is requested to apply with a modified. But this is the order. Twofold grounds. The route is covered more than 30% of the bus route, and also, my lord, 8 kilometers bus route has been covered. This is the resolution. My lord, after this order of Honorable Court, several permit was issued on the sales and route. In earlier occasion, offer letter was issued. That on the basis of that offer letter, permit was issued, page number 35. This permit was issued on the sales and route, Parulia Bazar to Samudragar station. That permit issued, page number 36, on 2nd March 2022. Just 1 month before this board meeting. That on our series of permit I have annexed. Date.
permit 19, 20, 21, but at the one latest permit. Now, my lord, I have challenged on two full grounds. What is the ground? The rejection, my lord, 30% basswood. And 3 kilometers basswood covered. My lord, the Union Transport Bardhuan, a quasi-judicial authority, in exercising power, the duty to consider the application of the petitioner for grant of contact with permit respect for Odisha. It ought to have mentioned in the said resolution which particular basswood is short for permit in excess of 30% of the basswood on which the petitioner proposed to operate his Odisha. That has not been mentioned. So it ought to have mentioned in the said resolution, even my lord, only rise to certain facts and figures and length of the basswood is required, this should have found place in the resolution. Otherwise, in absence of this, court cannot reach in the final decision. Because on the same issue, on the same ground, my lord, application was rejected. Several repetition was moved. For that time, my lord, at least, my lord, 40 or 45 repetition was moved, bunch of repetition. Or some repetition was moved, challenging the legality and validity of the notification. But that repetition was dismissed on the upholding the notification. And some repetition has been challenging the resolution 30% basswood and 3 kilometers basswood. And some repetition has been moved on congestion ground. That also considers in negotiation. That is the rejection of this also. So by this resolution is concerned, or this honorable court. Only relevant portion I'm placing because the big judgment 36 pages, but these are not delivered by Honorable Justice Dipankar Dutta, now is elevated to 53 now. So I am also very pleased to appear in so many cases with his lordship because he appeared on behalf of the petitioner, appear on behalf of the state. So my lord, I cannot forget those days fighting of between. So kindly, my lord, page number. Kindly page number. Paragraph of 53. On page number 349. 349.
Page number 349.
Page number 349. My page number. Paragraph. The paragraph 47.
349.
249. 249. 249. Paragraph 47.
Yes.
The petitioner represented by Mr. Raj had applied for an Odisha permit on an intra-regional road, Raj Mahal to SD Hospital. Before the Regional Transport Authority, Bardhuan, the RT Bardhuan, the application was rejected on June 17, 2012 by adopting the following resolution. The applicant was present at the time of hearing and was heard in the case record along with the inquiry report. The case is rejected for violation of notification number 268 W2/3M 012012 part 1 dated 29 January 2010 as the route is covering more than 30% of existing bathroom in road other than any self-importation. Now, kindly sir, observation and judicial observation of this report.
আমি শর্টকাটে বলে দিই my lord, exactly my lord what Lanet friend is stating my lord correct. Justice Dipankar Dutta my lord was my lord kind enough to help that the authority can reject an application for the carriage permit on the basis of that my lord the notification which has been upheld in that particular judgment, but say that if it appears that there is no further particulars with regard to that which route buses are being overlapped or sought to be overlapped, if the further permit is granted, then that should be disclosed. It has not been there. So, my lord, my lord, the Malanapin's clients, my lord, the read petitioner's case is covered by this particular, my lord, the paragraph number 48 and 49. So on the basis of this, my lord, the matter can be remanded back to the authority for further consideration, direction upon the authority to look into the matter afresh. And if there is any such, my lord, the overlapping of more than 30% of the bus route, if any further permit is granted, then the particular should be mentioned there. But then this is the what my landlord wants to, my lord, the place before your lordship. I say yes.
I'm
There
very
is
grateful
such-
because this is my case.
Yes.
So kindly remand back, revisit the matter. Yes, I'm doing because this is my kind of page now 48, 49. Kindly come.
Page kind of paragraph.
Sorry, paragraph 48, 49. Paragraph 48, 49.
হয়ে গেছে অনেক বলেছো
Thank you. Thank you.
এত টাইম
I'm
নিয়ে
very grateful.
হয় এত টাইম নিয়ে না না That's we can
But I'll give you observation. Because so many parties has been sold on this road. In the MC board, my lord, the report of the MBI submitted. So another board meeting, what's report of I do not know, but permit has been. So kindly that should be. Yes.
না এখানে তুমি কি কোনো একটা ছোট করে বলতে পারো
Applied for contact carriage permit for the concerned authority.
চিমিনিসের মাত্রা এটা রাখলাম নিশ্চয়ই
On 28th January 2020. The application is on 28th January.
The only thing, lordship, my lord, wants to record my lord, submission or averment that other permits have been granted. After the date of this resolution, my lord, it does not appear that any further permit granted on that particular route, my lord, stage carriage. And my lord, if anything done, my lord, that is, my lord, defaults the, my lord, rules or notification, then, my lord, that cannot be to the aid of, my lord, because any, my lord, no equity can be on that basis. And lordship, it may not be, my lord, required to record that because only on that basis matter can be remanded.
Yes, that will be.
The matter was placed before the
হয়নি তো ওখানে চিসে হয়নি
transport authority.
একজন হয়ে গেছে
And by a resolution of the RTA in a board meeting held on 17th March 2020. It was recorded. The petitioner was requested to submit modified route along with MBI report. Along with MBI report. Stop. Offer letters very soon. So several other operators upon approval of their respective applications. Pursuant to an order passed by this court, in several litigations on 23rd September 2021, directing the Regional Transport Authority to take up each of the matters in the next board meeting and pass necessary directions thereto. The petitioner's case was placed before the board and in a resolution taken in the meeting dated 30th April 2022, it was recorded that more than 30% of the route proposed by the petitioner overlapped bus route and also overlapped more than 3 kilometers of NH/SH, which is in violation of the provision of notification issued by the Transport Department. The petitioner was requested to apply with a modified route. The said resolution is under challenge in the resolution. It is submitted on behalf of the petitioner that the bus route as well as length of the route has not been specified in the resolution. That is your case. Paragraph learned counsel for the state respondents submits that it is a fact that the route length and the bus route
And the particulars of the bus route that may be overlapped, my lord, if the permit is
Yes,
granted,
and
that will not be
particulars-
mentioned.
and the bus route and the particulars of the bus route in respect of which the overlapping has been observed is not recorded in the resolution.
Right.
In view of the above, this court is inclined to hold that the authority may be directed to revisit the issue and record a reasoned order, a reasoned resolution specifying the particulars of the bus route which may be overlapped in the event the request of the petitioner is granted, and also the length of such route. Paragraph, the writ petition is accordingly disposed of directing the second respondent, regional transport authority.
Mine.
The second respondent. Accordingly, allocated. The resolution taken by the chairman, RTA, Purva Bardhaman on 30th April 2022.
But a resolution taken by the, adopted in the RTA board meeting itself.
Resolution taken in the RTA board meeting.
RTA board meeting in the response number 2.
Held on 30th April 2022, taken by the chairman of RTA, Purva Bardhaman, insofar as the petitioner is concerned, is set aside.
But taken by the RTA board itself. But the chairman only, one of the signatories. Otherwise, my lord, in the main file, my lord, the RTA board adopted by the RTA board, lords.
RTA board consists
Because
signature of both members also the chairman.
Left side of the chair.
Is set aside insofar as the chairman, insofar as the petitioner is concerned, is set aside. Paragraph, the second respondent.
Second.
The repetition is accordingly disposed of, directing the second respondent to revisit the request of the petitioner for grant of contract carriage permit in the next board meeting. In the next,
I do not know in the next board meeting, you know, only 15 days ahead or not.
within 1 month.
1 month. Yes.
Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, comma and accordance with law. Paragraph, the decision taken by the authority shall be communicated with the petitioner within a week. Disposed of, etc.
I mean, the allegations made herein are all denied because,
Since no other.
you're actually
973.
Same identical case.
It's 973.
Same resolution.
Same resolution.
Same resolution.
Mr. Sen, you're appearing?
No, my lord, somebody else.
All agree service is there.
No, no,
There is no one, it is served.
my lord, possibly, my lord, no one is appearing, my lord, but no one is appearing, my lord. But since, my lord, it has been served to the office of the government leader, somebody might have engaged. Lordship, kindly, my lord, at least one chance be given, my lord. I don't know who is appearing. Let him ascertain, my lord. Otherwise, difficult.
He is not supposed to ascertain.
No, my lord, maybe, my lord, maybe, my lord, no. I cannot say that I do. My lord, since there is a, my lord, court order, I have to. Only thing, my lord, let it be taken up tomorrow or day after tomorrow. My lord,
The state has to be diligent. No. The state has to be diligent. It has been served. If the state doesn't choose to appoint anyone, if you have any difficulty, I will not insist.
এটা কত 170
কত রেট 973 973
973 I
If you
leave
have difficulty, I'll not insist. I'll appoint someone else, but I'll dispose it.
very good.
The state should be more diligent.
True.
But I still hand over
In all the cases.
No, I do not know whether the person who is engaged any personal difficulty or not. That is why I said
That also should be mentioned.
should be
For the court.
mentioned.
So may I request you, Mr. Senator, from the review school. Please serve a copy, Mr.
Yes, yes, only one copy হলো আপনি জেরক্স কালকে দিন
Because the same order is required.
Same একই তো
একই same
Same order. This is also contract carriage.
contact respect order issue.
Next.
974.
Well, I didn't say.
The resolution is also the same.
Same, same.
Mr. Devra, same. Same.
ওইসব তিন এইখানে একই ম্যাটার নেই
975.
Same, but I pay lots. Well, root has not mentioned, root has not mentioned. Is the order?
No, it has not been.
It's different.
Only the resolution is.
Oh, resolution same.
Only resolution.
No, yes, it's separate. ones. They're all separate matters. There are two resolutions, the dates are same.
লর্ডশিপ লর্ডশিপ
975.
976.
ম্যাডাম এটা নিন একটু 75 এটা 76 লর্ডশিপ আইপি দাও দিলে তো
You're okay? 76.
লর্ডশিপ লর্ডশিপ
Same,
সেম সেম
same order being.
Kamla? Mr. 976.
প্লিজ এটা কেন
This
76
977.
Same, I think.
same resolutions also,
Same.
same order.
Nine 78.
Same, I think.
এটা
Same order.
979.
979 লর্ডশিপ আই
Same.
78 টা কি
This goes.
978 টা বোধহয় এ ছিল না হ্যাঁ পন্তু দেবরায় ছিল 978 978 তুমি দিয়েছো এই দাওনি তোমার এটা দিয়ে দাও
979.
Same, I think.
Same order.
979 আই
Yes.
এইটা
980.
Same, I think.
79 আমি আছি
980, who's second?
980 also my lord I appear
You're okay? Same order.
the PM is in আছে ওর সঙ্গে যুক্ত
981.
I am appearing last.
Same, I think.
Same orders.
Madam,
PM is in যুক্ত আছে ওর সঙ্গে এটা কি
81, 81 H.
980 এখন
981.
981.
982.
I am appearing last.
Same, I
Let time
think.
Mr. Now.
982 is also same.
Yes. I am.
983.
Yes, same, I think.
It's the same resolution.
আমি জোস
You've checked, Mr. Khan?
এই নিন এটা এই লিখে দেন 980 টা
But let them be disposed of.
That's not.
984.
Not benefit. Not benefit. Not much.
সব হয়ে গেছে
984.
Petitioner,
It's my application
984 is your application.
my
Punish Sinha. The petitioner.
9 so weak পড়ে
984 is Punish Sinha. Tobik Koral is 983.
no managing Deepak Bag
Yes,
985 Gunjan Singh only 984
984 agency.
only but in the only my matter is 984 so far my lord I have so we put a দর্শন তো একটা কিছু বলছে
The lists are not matching. One copy is 985, the other copy is 986.
না না অন্য কোনো লিস্ট চলে গেছিল অন্য কোনো লিস্ট আপনার কি স্টেট হয়েছে চলে যাবে
$984.
My lord, this is my
Yes.
application.
Yes. Yes, Mr. Mukerji.
What is facts? Well, the facts is that one of the vehicle. Well, under a hire purchase agreement, ready to us. Now, well, the owing to default, well, that vehicle has been seized by the financer. Now, we also will find that page, the inventory. Well, also at page 15, the inventory. Subsequently, when it is found that the vehicle has been sold by the financer,
Vehicle has been?
sold by the financer without going well, to any type of reference with regard to well, arbitrations or with regard to anything, without obtaining any well, order of the any court, well, they sold it. Well, your lordship will find.
The fifth respondent,
My lord, I have some. My lord, I have some. My lord,
financial services.
my lord, yeah, I have some.
They are the.
But I have some. My lord, the copy of affidavit of service. It is, my lord, your lordship kindly take it up tomorrow because affidavit of service has yet not been ready. Well, it has been served, they received it. Well, the private respondent.
After.
Well, only thing, your lordship kindly see how many days well, this matter is pending.
But you have.
But it has been transferred. Your lordship kindly see what is my prayer. Your lordship kindly come to last.
Please come back after every request. You missed your chance. Please come. Since service upon the private respondent is not complete, let the matter stand over till 9 June. 9 June.
$985.
Yes, 985. $985. None appears for the petitioner, no accommodation is sought. Let the matter appear under the same heading in the matter list of June 2020.
$987.
My lord, for this item, I am on behalf of the petitioner paying
Which matter?
987.
987, Mr.
Yes, I think on the other side.
Well, I am for the private.
You are a fixed.
Private is.
already. Private.
Well, I am for the private respondent. There are several private. Well, one of my, I am for the respondent number.
Two private respondents, same route, same.
Maybe, well, I am for the 12.
Private respondent 7, I have the copy. Service really, or to know.
You are for 12. Sir, you are appearing for?
My lord, I do not have the deep.
Are you appearing in this matter? Yes?
On behalf of the respondent, ma'am. On behalf of the respondent, I am paying not this week, ma'am.
Which respondent?
আপনার লয়ের নাম কি?
Mr. Arun Kanti Bera.
Respondent?
Yes, ma'am.
There is no such name.
Parasmalat is saying that the advocate who is appearing for the private respondent number 11, his name is, so I am not on the Parasmalat.
Officer in charge. Officer in charge.
I am sorry, I'm sorry that
No.
I'm 30. Respondent number 13, ma'am.
Are you sure?
13. 13.
Are
Respondent
you
number 13.
sure?
Mr. Arun Kanti Pera.
So there is not the respondent.
He is the advocate. On behalf of the respondent, now so far, my
It's
knowledge.
not a playground for us to play, isn't it?
I'm sorry, I do not have the brief now with me.
Submission, sir, without the brief.
Because Mr. Arun Kanti Pera, they are appearing for this matter, could not come today due to illness, very much illness.
This is very unfortunate.
I'm sorry,
You're
madam.
very it's now. Please keep that in your mind. Please do not let yourself
Sorry,
down.
madam. I'm sorry, I'm sorry, madam. The next, for the next time, next item also.
Affidavit of service. On prayer of the 13th respondent, the matter is adjourned.
You are being them all, like, I'm being.
Let the matter appear at the same heading on 13th June.
Ma'am, I. 13 June. Ligan in our one room.
Next.
Nine 88.
I am appearing. So first day. Led by Mr. Nat.
My lord, the same prayer, my lord.
Yes.
For the same prayer. On behalf of the petitioner, my lord.
On behalf of the petitioner.
I am appearing for state lordship led by Mr. Nat.
You are appealing for the petitioners. On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 22nd June.
Yes, sir.
989.
The application for grant of interstate. Stage carriage permit for the route interstate route. It is between West Bengal and Bihar and Jharkhand. Now, the application was taken up for hearing. My lord's order is that to take up the applications for grant of permit and consider it and dispose. But pursuant to my lord's order, when it was taken up for hearing, and my lord, it was decided. Your lordship, kindly straightway come. I will not trouble your lordship. Kindly come to page 29 of my book. And this is the decision adopted by the authority upon giving the opportunity of hearing. My lord, that has been done.
Page 29.
Page 29 of my. Your lordship got it. My lord, this is the decision of the board dated 8 December 2020. At the top, now the
8 December.
8 December. Now the agenda number 22. But decision. Now your lordship kindly, I will travel. Your lordship kindly come to they have decided to grant the permit in favor of my lord, some others. Only on the basis, the grounds taken, not granting me that according to the seniority of making the applications. But the date of applications only was considered.
There is your name in the resolution.
My lord. Your lordship will find the before that page, page 28, the applicants at the top, at the bottom.
But at the bottom, page 28, the name of the applicant serially, and your lordship will find that Samser Alam is serial number 3.
Yes, but in the resolution, where is your name?
Resolution the grantee man. Only your lordship will find in the resolution the grant in whose favor was made. Normally, lordship kindly see the earlier page, page 28, the applicant serial number 1, Ram Pravas Chaturvedi. He has been granted. The reasons of these manner, the consideration based on only the date of the applications. According to them, the first come, first served, who has filed the application first, he will be granted.
But it's strange that the name of the petition is not appearing in this order at all, in this resolution at all. It is appearing as applicant.
Well, this was, your lordship kindly see.
The resolution is not clear as to whether it was considered or not.
Well, your lordship, this starts, when your lordship kindly come, then your lordship kindly come to page 26. Grant of permanent, your lordship, has your lordship got? They are aware 4 applicants, all have been considered and granted in favor of the serial number 1, the applicant Ram Pravesh.
There is the rejection of petitioner.
There is no such. There are no, that apart.
Where have you rejected his prayer? Please show me. Where has been rejected first? Then only it can be granted liberty to apply afresh. Where is the rejection?
Your lordship kindly come to the last but one paragraph of page 29. Last but one paragraph, page 29. The grant, on what basis they have granted the applicant number 1. That has been there. So, I have challenged that the grant, but on which they have granted, but the basis of grant is completely without due course of law, because they are saying, because the person who has made the application the first, he will be granted, and that's why they have granted in favor of the applicant number 1. Your lordship kindly come to the page. Sorry, sorry, this is not an inter-regional route. This is an interstate route, and the quota has been fixed by both these states, and there is only one quota. So that has been filled up. The question of making a fresh application and to be considered in where. So that's my application was for the interstate route, and there is only one quota. The vacancy was 1.
Mr. Devra, can this be a ground for allowing or rejecting? Because it cannot be on the basis of, cannot be a first come first served basis. There are other criteria to be considered. Let him come back, Mr. Affidavit of service. Learned counsel for the state respondents submits that though he has received some instructions in this matter, he requires further instructions. Paragraph, let the matter appear under the 19th June.
And in the meantime, not to give any effect to the resolutions, because in the meantime, if they granted the offer letter,
Yes.
then I will be here.
Not possible.
Private respondent has not been party, has not.
Nothing has been given there, Malad, the details were. At least resolution should be not given effect to. Malad, I'm not asking, resolution.
Respondents' rights would be affected.
Malad, your lordship kindly see, if they, in the meantime, at least Malad, only thing Malad, then Malad, let them.
Any step taken to abide by the resolution. Paragraph. Any step taken by the respondent authorities. In terms of resolution in queue. Dated 8 December. 8 December 2022. Shall be subject to the result of the. Shall abide by the result of it.
Well, only prayer is that leave may be given to Malad so that I can make the party the private response.
Very good. On prayer of the petitioner, liberty is granted to impede.
But the grantee, the applicant's number 1, Malad, the grantee.
Ram Pravesh Chaturvedi.
Man. Subject to furnishing of the.
The details.
Well, subject to addressing, subject to furnishing the address by this. Because last occasions also your lordship is directed in another matter, which is coming tomorrow, my lord. There is also they furnish the details about it. Because that is not their house.
Unofficially or I cannot. As
My lord, my lord, my lord.
5 in the writ petition, paragraph, the petitioner is directed to serve copy of the writ petition along with annexure thereto upon the added respondent and file affidavit of service on it.
My lord, before my lord rises, my lord, only one. My lord had allowed my mentioning that I mentioned one term number 156 of today's list. My lord directed the matter to appear on 17th. The eviction is being given. My lord, only my lord, on 17th at 10, my lord, I mean the eviction is